Yeah, Lordship's kind leave to mention one extremely urgent matter. Lordship, remember, in connection with this particular matter, Lordship has taken this matter on Friday at 2 p.m. But due to resolution of the bar, my lord, the matter is posted today at 2 p.m. My lord, what has happened, my lord, on the evening of Friday, my lord, they have rejected my appeal. Now, this appeal was served upon me in email yesterday.
Why are you mentioning a 2 p.m. matter?
2 p.m. matter, my lord, that matter I have filed challenging the termination and the issuance of the tender. Now, this matter, Lordship, is seeking leave because they have rejected my appeal out of that same tender, same train. Lordship, if that writ petition is not filed, my lord, challenging the appeal, my lord, they will take a plea that the cause of action has changed. So I have taken out this writ application, my lord. Lordship,
Withdraw the earlier application.
no, withdrawal, my lord. I tell Lordship, the cause of action remains in both the cases because that was filed challenging the tender and determination. Now, this has been filed challenging the appellate orders regrettal. So, both the matter may be taken up together, my lord. Has restrained the Lordship has requested, let it be leave may be granted, my lord.
Lordship,
Yes.
may be permitted to seek leave, Lordship, to file the urgent application, Lordship, that NH authority has acquired the land. They have calculated the quantum, Lordship, and another after 25 days, they have sent the money, Lordship. Now they are saying from the day when they calculated the day for quantum, Lordship, from that day 60 days will be counted, and that 60 days is commencing on tomorrow, Lordship. And tomorrow they will come and demolish our structure, Lordship.
File and come. They'll not
Lordship,
demolish your structure.
tomorrow,
File and
Lordship. 13
File
is
and
the
come
day,
back.
Lordship.
File and give the number.
My lord,
Lordship,
may I permit to mention?
Compensation. So the public.
no,
cannot be
Lordship, no,
halted.
not the compensation. No enhancement of compensation.
That
Now,
is compensation, sir. You're agreed by
Lordship,
the
tomorrow they
compensation.
will demolish my.
Maybe you'll get compensation.
Lordship,
File and come.
there are so many.
Yes,
My lord, may I
I can
permit to
serve
mention
the
a matter for
copy,
urgent
Lordship.
hearing?
File and come.
My lord, respondent number 13 being the government hospital without any process of
Are you
acquisition.
mentioning upon notice?
Yes, my lord. My lord, respondent number 13 being the government hospital without any process of acquisition, encroach the petitioner's land.
Give the number. Give the number.
And with notice to other side, I have given ministry for manipulation of the.
What is your urgency?
Position is being disturbed.
Give the number.
My lord, may I be permitted to mention this upgradation, my lord, item number 363 of the.
Upon notice?
My lord, I will serve notice,
No.
my lord, in the meantime. My lord, kindly, my lord.
Please
My
mention.
lord, item
upon-
number 363 of the
Be the
list,
first
my lord.
line of my list, sir.
My lord,
First page of my list.
with regard to my lord 101, my lord, this matter may appear under the heading, my lord, to be mentioned, because my lord, probably this will not be heard by man. Because,
You're mentioning upon notice?
no, because my lord, this matter was taken up by my lord Justice Sengupta, and my lord, wrongly it has appeared, we have not mentioned it. That is why, my lord,
You are mentioning the matter for release.
for
So it
releasing,
should be in presence of the other side.
my lord,
Please put them on notice and come back tomorrow.
Determination.
my lord, not
should be aware.
determination, that is why, my lord, I was.
I understand, but it cannot be behind their back.
If I may have, my lords, kindly, my lord, to mention a contempt matter, my lords, for inclusion in your
Fresh
lordship's list. Fresh contempt, my lord.
Give them.
My lord, for the
Grateful, my lord.
inclusion in the list on land matter.
Upon notice?
Upon notice.
What is your urgency?
My lord, BL and LRO is not letting me to enter my land on my own land. They are serving several time of notice to.
Give the number.
My lord, may means, my lord, 489 item number for upgradation. My lord, urgency is, my lord, the in front of my shop room, my lord.
You are mentioning upon notice?
My lord, new motion, my lord. I have served all, my lord.
New motion also you have to mention upon notice.
My lord.
This is the upgradation, my lord, this is the.
Upon notice?
I have given the notice.
My lord.
I
Have you given notice?
Yes, man. I have the notice.
My lord,
What is your urgency?
Urgency, my lord, petitioner did not egress or ingress in front of the petitioner. They are.
The number.
my lord, I have already mentioned the matter on Thursday, but my item number is wrongly put in the mentioning slip. So
Are you
my-
again mentioning upon notice?
Yes, my lord, I have mentioned this and I have already.
Are you
served the
mentioning upon
notice.
notice, madam,
Yes,
today?
my lord. Yes, my lord.
Upon notice?
The application I have served upon.
You have to mention upon notice. I make it very clear. Please do not mention without notice. I will not take up matters.
served the petition from them.
Maybe, but you have to mention. You have to mention upon notice.
Unless and until, my lord, my lord,
Notice of
take the
mentioning,
application-
have you served?
my lord,
Notice of mentioning, have you served?
my lord, unless the application reaches them, my lord, how can I serve the notice? Because, my lord, I'll tell you, lordship. This
What
matter-
application is it?
Yes, that is what I said. My lord, matter was mentioned before your lordship without serving us notice. Matter was updated from monthly list to the daily list. Matter was heard, passed.
So there is someone for the other side?
My lord,
There is an advocate for the other side?
yes, my lord.
So please serve and come.
My lord, but I have to serve.
Mentioning will not be taken up without serving the other side.
My lord, I have to
Becomes
serve-
very difficult otherwise.
serve and come.
But may I be permitted to mention a matter for extension of the interim order which is expiring this
Upon
Friday?
notice to the other side? Are you mentioning upon notice?
No.
No. So mention.
May I have my law-
Interim order is expiring Friday
You are
only.
negligent in that case? You should have served.
May I have my lord's leave to?
Milord, I have served, Milord.
Without notice, I will not include it.
No,
Let me
Milord,
make it very clear.
Milord, I have served, Milord.
The mentioning you have served.
Milord,
You're
I have served. I have served, Milord.
You're mentioning upon notice.
Serve the notice for mentioning
Milord, I have served, Milord. I do have.
or upgradation also. Urgency is the impose the PW land in front of the
How many matters?
lawsuit.
How many matters?
One
One matter?
May I have my
notice.
Give the number.
May I have my lord's leave to mention one matter upon notice for extension of interim order. My lord, the interim order is expiring on this Friday. The matter is also running in my lord's list.
Extension of your.
Grateful, lord.
Upon notice?
Paying for application,
What is your urgency?
Your lordship is directed to matter to appear after 4 weeks regarding by the encroachment of the plot. The state has submitted request and the preemption of the land. Or matter has not appeared.
Give the number. Upon notice? You have mentioned, notice of mentioning has been given? Then please do not mention any matter without notice. Notice of mentioning. You have to mention upon notice to the other side. Have you done that? No, you have to do that. and come back.
May I be permitted to mention one matter before your lordship, my lord, 588. As per your lordship's direction on my lord Wednesday, your lordship was directed my lord to be my lord mentioned today. My lord, for upgradation of the list,
Are you
your lordship
mentioning
has
upon
been pleased to
notice?
fix the matter.
Are you mentioning upon notice to the other side?
Yes, notice has been given to Mr. Banerjee and he has received the notice.
Notice of mentioning, not.
My
the
lord,
application.
regarding the matter, my lord, your lordship was pleased to my lord fix the matter last Wednesday,
So
but
you're
the matter
mentioning
has
upon
calmed down.
notice.
Your lordship.
Give the number.
Your lordship, may I be permitted to mention?
শান্তনু যেগুলো নোটিশে মেনশন হবে না নেবেন না লিস্টে ইনক্লুড করবেন
Your lordship, may I be permitted to mention for inclusion of 2020.
upon notice
Upon notice, this matter was taken up on 5th December before Honorable Justice Sugata Bhattacharya. The matter was mistakenly filed under Group 9. So leave was taken and this
it will be
matter
under
was
group 1. It will
Group
be under
one.
group 1. Give the number.
May I kindly be permitted to mention a
and
matter?
earlier two notices were given.
Are you mentioning upon notice today? Where is the
Not a
notice?
fresh notice, but earlier
I have requested you to mention upon notice, otherwise it will be a futile exercise. I will not include, it will just be thrown away.
I'm praying for inclusion of a new motion, Lordship. It was filed on 19th.
You're mentioning upon notice?
Lordship, this was filed in 19th and then subsequently it never came up on the list, Lordship. I'm just
Mention
praying for
upon
inclusion.
notice. Mention upon notice.
My lord, two similar matter, upgradation of
Upon notice?
Yes, my lord.
Yes, yes.
This matter, my lord directed the matter will appear on 4th of this month. But matter was appeared in the monthly list as item number 420, 421, 422. The matter was heard, my lord.
Difficulties,
On 3
4th of this
occasions.
month was monthly list day.
My lord,
4th of this month was monthly list day. That's why it is appearing in the monthly.
monthly matter will not come.
Are you mentioning upon notice to the other side?
No, I already intimated Mr.
You have to mention upon notice, otherwise I will not include the matter, sir.
All right,
mention
today I mentioned, my junior
I
will
will not
mention.
accept mentioning without notice.
Yes, madam,
Please mention
today I already intimated Mr. Day, 27th day, but verbally. Yeah, for upgradation, and matter was fixed on.
Verbal intimation is not.
All right,
sufficient.
my lord. All right, liberty be given to mention the matter tomorrow.
Yes, yes.
I shall.
Absolutely.
I
Please,
shall
sir.
start.
My lord, this is for upgradation. So there are around 7 matters, my lord.
For notice?
Yes, my lord, for notice.
Why 7 matters together? What are the matters about?
My lord, the BDO has issued a notice upon us on 22nd November. And as per the notice, he said that within 15 days, that is on 7th December, you have to vacate the plot. So this is the urgency, my lord. Yes, notice has been served, my lord.
Yes, give
Lordship, may I be permitted to mention one matter for application of recalling your lordship's order? The thing is,
mentioning upon notice?
yes, lordship. The thing is, the petitioner suppressed a material fact that the title suit has been pending.
Give it up.
Your Lordship, may I be permitted to mention item number 492 of this monthly list
Yes.
for non-prosecution?
Upon notice?
My lord, may I,
Not upon. Serve
may I
notice
be
and come.
permitted to mention one matter?
Other side should be aware, isn't it? Serve and come back tomorrow.
My lord, may I be permitted to mention one matter, my lord? Upon notice, I am praying for upgradation, my lord.
Why? What is your urgency?
Urgency is that one of the respondent authority has threatening my client to for vacating his property land.
Give them.
My lord,
May I permit it?
my lord,
May I permit it to mention item number 762, Lordship, for upgradation with notice, Lordship.
What is your urgency?
Lordship, the respondents are trying to dispose me, possession of the land is till now with me, but land has already been acquired without paying any compensation, Lordship.
Give them.
my lord, you just allowed my mentioning right now, my lord. Can you fix this matter from 500? We have mentioned it. 7 matters, my lord. Tomorrow, my lord, anytime.
Appear in the list. Let us see.
Lordship,
Appear is mentioned matter tomorrow. Don't worry.
Lordship, may I be permitted to mention, Your Lordship, I am mentioning upon notice, Your Lordship. This matter is of Rupita Ghosh, Your Lordship, and it is pending for very long, Your Lordship. If Your Lordship may allow this matter. This matter is appearing as
It's not in the list at all.
Lordship in the monthly list as item number 327,
Give the number.
Lordship.
Lordship, may I be permitted to mention another matter? This is extremely urgent as the authority concerned is threatening to.
Mentioning upon notice?
Yes, Lordship. Yes, Lordship. This is for inclusion in urgent listed motion, Lordship.
Give the number.
And Lordship, another mentioning.
You mentioned together, sir.
Just for inclusion in the list, Lordship. This is pertaining to unauthorized construction.
You are mentioning all of the.
Yes,
notice?
yes, Lordship.
Where is the notice? You've annexed it? You've annexed it?
Yes.
Your Lordship may be, Your Lordship may be allowed to mention one matter. Your Lordship, item number 615, the monthly list. Your Lordship, new motion. Your Lordship,
Upon notice?
Your Lordship.
Come back.
Lordship, I may permitted to be mention a matter. Lordship, the matter running today, Lordship cause list item number 301. Lordship, it's a new motion matter related to transfer of mutation, Lordship.
Yes,
So, Lordship,
transfer
kindly.
of mutation.
Yes, transfer of
You-
mutation
you
application. This
notice to the
it's
other
covered
side.
by Lordship judgment,
Where
Lordship.
is your mentioning slip?
Lordship, I am prepared.
Verbal mentioning is sufficient, sir. You just see and the court records. That's not the rule, isn't it? Please serve the other side and come back. You have to mention upon notice. And where is your mentioning slip? You're only mentioning verbally. Is that
No,
sufficient?
Lordship, I am preparing and
You're preparing. Get ready and come back.
Lordship,
You
may I
have to serve
be
the other side also.
Lordship, may I be permitted? Your Lordship, I am mentioning a contempt matter that was filed by us in a writ petition 8508 of
Fresh
2023. Yes,
New
Your Lordship.
contempt matter?
Your Lordship.
Give the number. Yes, call the day's response.
Calling from to the list. Item number 1.
My lord, I beg to My lord, I beg to appear on behalf of the petitioner.
Yes.
My lord, on the last occasion, I did not have the Vakalatnama to appear on behalf of the petitioner, so I'm submitting the fresh Vakalatnama today. My lord, I have been instructed by my client to withdraw the matter as they have reached amicable settlement. So, my
Due to
lord,
amicable settlement.
yes, my lord,
Similar days. It was with regard to non-payment of compensation, my lord.
they have the
But we have
respondents
also received a letter from them, my lord, saying that
No.
The petitioner seeks to withdraw the writ petition due to amicable settlement arrived at between the parties. Paragraph, in view of the above, the writ petition being WPS such and such is Dismissed for non-execution. There shall, however, be no arrest to costs as in certified website. Next.
Grateful, madam.
Grateful. Much obliged, ma'am.
Item number 2.
Lord, I beg to appear for the petitioner.
My lord,
Lord,
before my
on
senior friend start, my lord, may I submit, my lord, if your lordship kindly allow me, lordship, to peruse the first paragraph of this order, my lord. My lord, in this case, my lord, on the last occasion, my lord, I prayed an submission, lordship. I made the submission that National Highways Authority has no role. But my lordship, inadvertently, my lordship, it has been written the competent authority has not been role. And lordship, and also lordship, the competent authority has the my lord, though lordship, there has been mentioned under the lordship for extension of interim order, my lordship. But if this correction is not been done, lordship, the entire petition become infructuous, lordship. One hand, lordship, the competent authority has been expunged. On the other hand, lordship, the competent authority has a direction to file a affidavit, lordship.
may I make it clear, my lord?
Yes.
Lord, after we filed the writ petition, Justice Chaudhary, my lord, passed an interim order. Lord, kindly take the order, my lord. Kindly take, my lord, the fourth page of the order. Order dated 18th October, fourth page. My lord has kindly got it, my lord. 18th October.
Yes,
Fourth page, last paragraph. Since section so and so creates a bar on taking possession of the acquired land before payment of entire compensation, if the land in question is in possession of the petitioner, as on date, status quo in respect of such possession shall be maintained by both the parties till 15 December 2023. Lord, this is an acquisition under the National Highways Act. Lord, the notices are issued under the National Highway Act. Lord, my learned friend, Lord, Miss Roy, Lord, she made a submission before Justice Chaudhary that National Highway has no role to play. But now kindly come back to the second paragraph of the order at page 1. Lord, his lordship, Lord, perhaps while dictating the order, Lord, has Lord recorded that respondent number 1 and 8 should be expunged. Lord, kindly have a look at the cause title now. Lord, respondent number 1 is the Union of India. Lord, I am saying that Union of India cannot be expunged, and Union of India has not come up and said that. It's my writ petition. Lord, being the petitioner, Lord, I have a right to, Lord, add him, Lord, the respondent Union of India as a party. Lord, that was wrongly done.
Lord, respondent.
Now kindly see 8. Who is 8?
Competent
authority. Competent authority. If the competent authority goes, then nothing would remain. That's a wrong recording. What my learned friend want.
Not a wrong recording. It is on merits.
No, my lord.
No, not on merit.
No, my lord.
Not on merit.
My lord, kindly come to the first paragraph, my lord.
First paragraph, that was on their prayer. Though Union of India, yes, it was on her.
Lordship, my submission is National Highways Authority has no role, my lord. It is entirely the competent authority. The NH81 is under the control of PWD, my lord. Well, I have the documents, my lord, to show. But my lord, kindly see, and after my submission.
8 is rightly expunged in that case.
No, no,
My lord,
competent.
it is competent authority, my lord. Here the competent authority is the answering. My lord, here, my lord, the instead of 8, my lord, that should be respondent number 6, my lord. That is the project director.
Lord, I would say, since I am the petitioner, if they have no role to play, let them file an affidavit and explain it.
Not necessary.
But my kindly.
The court has already held that the National Highways has no role to play. Only the number has been mentioned wrongly as
Yes. Now, what I say, Lord, with greatest of respect to your lordship, Lord, the acquisition which I am challenging.
I'm not on merit, sir, at the moment. Let me correct this order. It appears to be a typographical mistake. I'll extend your interim order for some time. Who is appearing for the state?
My lord, Mr. Amal Kumar Sen is appealing for the state, your lordship. My lord, I'm praying for extension of time to file affidavit, your lordship. My lord, kindly. And now, lord.
But Lord, kindly appreciates one thing.
Yes. The first paragraph, my lord. So the Union of India and the competent authority under the National Highways Act under 1956 are arranged as respondent number 1 and 8, comma, they do not have any role. Well, that is the difficult one. The competent authority has every role, my lord. Instead of competent.
I'll make it 6.
My lord, I'm grateful, my lord. Only
But Lord, 1 cannot be removed. Lord, 1 is the Union of India.
Been removed.
But
I cannot change.
Lord, that was she is saying Union of India.
One is not a typographical mistake. It was passed in your presence.
Kindly have a look at the first paragraph.
My lord, another thing, my lord. Interrupt, my lord.
Both of us
Another
cannot
thing is,
speak.
my lord, the first, if you lordship kindly see the first letter I have written, my given me my learned friend. Here, my lord, respondent number 8 is mentioned as two, my lord. One is 8 is a project director, another is competent.
That is a communication, not
only,
a
my lord.
record.
That is the, maybe that.
Lord, only one thing, Lord, kindly just bear me for a second. Lord, Union of India did not.
Explanation at this stage. I'm sorry.
Lord, just hear me
You
for
have
one.
not explained before the coordinate bench when it was
Lord,
done.
just hear me for 1 second. Then my Lord passes the
I
order.
cannot. I cannot change this order.
Lord, I am not asking your lordships to change.
Futile exercise.
Lord,
One cannot be kept.
Lord, Union of India did not appear and make that submission. Union of India did not appear. There is no appearance for Union of India. It was only the project director whose removal was prayed for.
I have not considered this at the moment. It was dictated in open court in your presence. You have not made any objection to that. Inadvertent error has crept into the order passed on 18th October 2023. Paragraph in the said order.
বলতে পারছিস আমাকে এতদিন প্রথমবার বলছি ইউনিয়ন অফ ইন্ডিয়া চলে গেলে মুশকিল
The competent authority under the National Highways Act, 1956, within bracket, respondent number 8, be read as the project director, project implementation unit, Malda, National Highways Authority of India, the respondent number 6. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order, that is the change. Paragraph, this order be treated as part of the order passed on 18th October 2023. Paragraph, the remaining part of the order shall remain unaltered. Paragraph, learned counsel for the state respondents seeks extension of time to use the affidavit in opposition as called for.
Second last paragraph, page 4.
Affidavit in opposition be filed within 2 weeks after vacation. Within 2 weeks after the ensuing vacation. Stop affidavit in reply, if any, be filed within a week thereafter.
2 weeks.
2 weeks. Within 2 weeks thereafter. Paragraph, the interim order granted earlier is extended till 29th February 2024, or until further orders, whichever is earlier. Paragraph, let the matter go out of list for the time being, liberty to mention.
Lord, only one thing, if my lord now hears me for 1 minute only. Lord, nobody has prayed for respondent number 1's deletion. It is only the respondent number 6 was prayed.
I cannot change it.
Lord, since your lordship
a
has
typographical mistake, it is a consciously passed order.
since your lordship has corrected 8, Lord,
Yes, because it's a typographical mistake. 8 is
Lord,
not the National Highways Authority.
that is true, but no one has prayed for it. All of
That
us
is
are
true.
here.
Please do not make further
But
submission.
all of us are here, my lord, before your lordship. My lord, we are unanimously saying one
But
was
there before his lordship on that day also.
when it
Next
is
matter.
Item number 3.
This has come up at my instance, the petitioner, for extension. Where the order was passed on 18th of October.
Yes.
This is the respondent side. Oh,
For abundant precaution, my learned junior has filed an application for extension, but the interim order is still surviving.
Not necessary.
Yes.
Yes, respondents.
we are for the respondent. 2, 3, and 4.
Affidavits were called for.
Affidavit within 3 weeks, within 3 days, we'll be able to file. Everything is ready.
Drafted 3 days. Next submission state. So you don't need to file affidavit. Because all the respondents were directed.
Yes, yes.
So shall I record that the state doesn't need to file? I'll record. The Can 1 of 2023 third.
No, sorry to interrupt. Only if making my lord, if the interim order, naturally they have got their order, interim order. Yes, that's what I'm getting.
Learned counsel for the state respondents submit that the state does not intend to use an affidavit in opposition in this matter. Paragraph, learned counsel for the other counsels for the other respondents seek extension of time to use the affidavit in opposition as called for. Paragraph affidavit in opposition be filed within WP along with CAN. Should CAN go. WP along with CAN 1. And equal to WP. Within 2 weeks after the NC.
No, by Monday I'll file. Everything is ready by Monday. Affidavit we file by Monday.
Within 1 week. Affidavit in opposition be filed within 1 week from date. Stop affidavit in reply, comma, if any,
Right.
comma, be filed within.
1 week after the vacation.
After the vacation, within 1 week after the ensuing vacation.
Paragraph,
the interim order granted earlier is extended till 31st January 2024 or until further orders, comma, whichever is earlier. Can 1 of 2023 is disposed of.
I'm grateful.
We are going court.
1 week after.
Appeal provision they came on DPH. The judgment is really, I couldn't come at that on that day. I'm grateful. May I leave?
Next.
Item number 4.
Please, Your Lordship, I am for the petitioner. On the previous occasion, it a petitioner,
Yes.
Your Lordship had been pleased to pass a peremptory direction on the last occasion.
Yes, what is the matter about?
My Lord, I am a Government of India enterprise and I have a technical services center at Balitikudi, Howrah, and the land was acquisitioned in 6061 to set up this technical services center, Your Lordship. Then in the 1970s, I paid some more amount to have an approach road acquisition for my favor. So about 125 acres, my Lord, were acquisitioned for setting up of my center. In the 80s, my Lord, the state government requested the central government to have some portion of the land, about 76 acres, transferred. At that time, they asked for permissive possession to be transferred in favor of the CMDA, the then CMDA. My Lord, the central government directed me, and the requiring body was the Commerce and Industries Department. They had made a prayer, and the central government directed me to effectuate this agreement. I did. In 2004, my Lord, a formal agreement of such transfer was also recorded in favor of KMDA. By that time, it had become KMDA. My Lord, since the 1980s, I have been writing to the government to execute a formal deed of conveyance in my favor because, my Lord, the acquisition was in 1960s.
In respect of the remaining portion of.
In respect of the remaining portion, 48 acres, Your Lordship would kindly peruse Your Lordship's first order in the matter. And there have been interdepartmental correspondence, which I have produced with my petition, Annexure P5. I'll take Your Lordship to some of these correspondence. On 2 occasions, the state had sought time to take instructions.
Yes.
Lordship, as per my written instruction, Lordship, the land was not acquisitioned as chapter 7 of section 38 to 44B as LR Act 1894. So there is no obligations of the LR authority to make a deed of conveyance. This is my written objection. Lordship, let I file the affidavit in opposition if required.
Have you served a copy to the petitioner?
No, my Lord.
This is only one copy. I will give you.
My Lord, may I take Your Lordship through some of the correspondence that the respondents have written?
Yes.
And
This is the
Your Lordship
objection,
would
Lordship.
kindly thereafter determine whatever objections that they're now coming up after 70 years.
They say that it was not acquired at all.
May I, my Lord?
Please, yes.
Yes.
Please show me the documents.
My Lord, the acquisition proceedings, Your Lordship would find at page 11 to 14. My Lord, at page 11, the second paragraph, this notification is made under the provisions of section 4 of Act 1 of 1894 to all whom so and so, so and so. And thereafter, my Lord would kindly,
And your land is included here?
my Lord, this is only for my land. My Lord would kindly see the first paragraph. I'd place the first paragraph, Your Lordship, whereas it appears to the government that land is likely to be needed for a public purpose. So and so for the establishment of an industrial training institute and a mechanical workshop in the village of Balitikudi jurisdiction. My Lord, the entire land was only acquisition for setting up of this industry, of this technical center. At that time, it was a collaboration between the Indian and the Japanese governments, and thereafter.
So what is the plot number? You've not stated it in your writ petition.
My Lord, the plot numbers, my Lord would kindly see page 12, some plot numbers are indicated.
Page 3 of the writ petition. The Everments, where is the plot number stated?
Milord, those plot numbers have not been mentioned because it's 48 acres. If your lordship so wants, I can file a supplementary affidavit to just indicate the plot numbers, but I have also produced
Even
documents.
the CS plot numbers are recorded in the 4-1 notice.
There. And Milord, even thereafter, I had written to the authorities and they had also indicated the plot numbers. Milord, would kindly look at annexure P5, which is the correspondence. And I shall thereafter take your lordships through to
You're
lordship
at
through.
page?
I'm at page 51, your lordship. Annexure P5.
Yes.
This is written by respondent number 2 to respondent number 3. Respondent number 2 was the requiring body. Your lordship kindly sees the second paragraph. In consultation with the LR department, which is respondent number 1, this government, the undersigned is to state that a deed of transfer in favor of the corporation may be executed in the form prescribed. So now today, your lordship, the state comes up with yet another excuse. I'll take your lordship through other correspondence. This is from R2 to R3, which is in consultation with R1. Your lordship would thereafter kindly turn over to page 52. This is by R3 to R1. Collector to LR department. Your lordship would kindly.
Who will execute the deed?
As to who will execute it.
Execution is not challenged.
This is never challenged, Milord. It is only a case of bureaucratic football from the 1980s right up to 2018. And Milord would kindly see the last correspondence this was exchanged between the state interdepartmental correspondence.
61?
Page 61. Yes, Milord. I'm obliged. 61 at page 62, your lordship. So this is all that has been going on. And your lordship had been pleased to remark on the first occasion that this is, I mean, this remark was made to Mr. Ganguly for this state that this is a simple matter. Let's not complicate the matters. This fell from your lordship that the documents are very clear. Nobody has disputed my possession.
Mr.
Nobody
Ganguly
has
is
said.
my senior counsel, lordship. Lordship, let I file the affidavit in opposition.
Not necessary. I'll pass an order. I'll dispose of the writ petition here and now. There are several communications which say that that deed has to be executed in favor of the petitioner.
Lordship,
You
but
cannot take a U-turn now and say that you have not acquired the land at all.
it is a very old acquisition matter, lordship.
Yes. So
Lordship, kindly.
it has been acquired.
No, lordship, there is no many documents is not.
Please come to the page 11 of the writ petition.
Yes, lordship, I see.
Then, and the correspondences, page 51, 52, 61, 62. What other document do you require?
Let I file in one only short time, lordship. Let I file
necessary
in
at all.
opposition, lordship. It will
Not necessary. Several dates have been given to you. Today I will not grant any adjournment. I'll dispose of the matter. There should be a limit to everything, isn't it? The state cannot continue like this. The transfer and possession was made verbally
No, Milord. The transfer.
of the land.
Yes,
land.
yes, the transfer was, I was just put in place. I mean, after the acquisition took
No
place.
possession certificate also.
No possession certificate. That is my problem, Milord, that I cannot get the land mutated in my name.
How do you show that you're in possession?
I show I'm in possession, Milord would see the electricity bills. I have annexed the electricity bills to show that I am in possession, and it is fairly undisputed, your lordship. They have never disputed my possession, and my lord, my possession, some part of the possession was
Acknowledgement in any of the letters to say that you are in possession of the property?
my lord would kindly give me a moment. And my lord, to show that I am in possession, the electricity bills, your lordship would find at page 48, annexure P4.
This annexure doesn't show the dark numbers on anything, isn't it?
That it doesn't, your lordship.
If they are denying the acquisition itself, please show me a document that you are in possession of the.
My lord would kindly.
You're carrying on business there.
Yes, my lord.
So your business documents.
My lord would kindly see page 56. The collector writes to the director NSIC. Page 56 and 57. Plot numbers are indicated. The total area is indicated, your lordship. This is from the government to my director.
This is particulars of the plot number.
Yes, ma'am.
Possession.
My lord, since it
You're
has been
asking for
fairly
execution
understood.
of a deed.
Yes, my
Isn't
lord.
it?
And I had, my lord, I had also written to the state after page 62, my lord would kindly see the demand for justice. This was never replied to. So any denial was also never made throughout the course of inter partes correspondence or even after the stage of that. My lord would kindly see page 60.
Make a representation before the state.
I did, my lord. Page 64.
This is a demand of justice.
Demand for justice, my lord. This was unanswered. So, my lord, any further representation before the state would.
Where is the answer to this?
There is no answer, your lordship. This was received.
So why don't you, because since I cannot direct disposal of a demand of justice,
No,
isn't it?
No.
So why don't you file a comprehensive representation annexing all these relevant documents?
I did, my lord. This demand for justice had all these annexures. These demands
cannot be directed to be considered by the state.
Lordship,
And that it was way back in 2022.
Lordship.
We are almost in 24. Why don't you file a comprehensive representation?
Lordship pleases.
Let them dispose it of within 1 month. Yes.
As the Lordship pleases.
Since learned counsel is not able to apprise the court, and I do not find any possession documents
I shall make a representation, your lordship.
with these documents.
With these documents, your lordship.
You have to make out your case in the first instance, isn't it?
My lord, the deed for transfer also notes my possession. The deed for transfer which was executed by me in favor
Where
of
is that? You've
KMD.
annexed
Yes, my lord. My lord would see page 35.
This is between you and the KMDA.
This is me, between me and the KMD.
Please file a comprehensive representation
Lordship, please.
annexing all these documents.
Yes, Lordship.
Heard learned counsels for the parties. Paragraph. It is contended on behalf of the petitioner that
I'm sorry, my lord, to interrupt, my lord. Just one page, my lord, would kindly look at page 52.
Yes,
This
you
is
just
from
pointed
respondent
out.
3 to respondent 2. Sorry, respondent 3 to respondent 1. My lord would kindly look at the second paragraph. The third line. The scheme land has been acquired after observing the formalities under the Act, and possession of the land has been handed over to the assistant engineer, PWD, so and so, Commerce and Industries Department. And my lord, there is correspondence from the state which says Commerce and Industries was the requiring body, so it may hand over the possession, execute the deed in my favor.
it is said that the Director, National Small Industries, that is your client,
Yes, ma'am.
requests this office for transferring the land by a deed of conveyance. So it has not been transferred
It hasn't.
as it comes from this letter.
Yes. That has been my prayer all through, my lord, that there has been no deed of conveyance or transfer, despite the state agreeing that there should be a deed of transfer or conveyance right from 1980.
So it is the state's discretion. Let the state decide.
Lordship pleases.
It is contended on behalf of the petitioner that on acquisition of the
May I finally take one more liberty, Your Lordship, to interject one last time? My Lord would kindly look at the last paragraph of page 52. This is an admission, Your Lordship.
yes, you are in possession. I'll record that. I'll record that.
Lordship, please.
That will help you. কি বললাম? Of the plots in question by the LA collector, Howrah, for public purpose, the land was possession of the land was transferred in favor of the petitioner. Stop. Though the state respondents decided to transfer the land in favor of the petitioner, the deed of conveyance has not been executed till date. Paragraph. Learned counsel for the petitioner takes this court to page 52 is annexure.
Annexure 5, my Lord, P5.
Annexure P5 to the writ petition. P5 না করে করুন, takes this court to a letter. P5 টা কেটে দিন. A letter issued by the Special Land Acquisition Officer within bracket General bracket closed Howrah to the Deputy Secretary to the Government of West Bengal, Land and Land Reforms Department, LA branch on no date of the letter, page 52.
My Lord, 3rd December 1983, right at the bottom, my Lordship.
On 3rd December 1983, which indicates that the land in question is in possession of the petitioner and the letter requests consideration whether deed of transfer would be executed by the collector, Howrah, or by the Commerce and Industries Department as the requiring body. Stop. Paragraph. It transpires from the documents on record that the petitioner is in possession of the plots in question and the state respondents agreed to execute a deed of conveyance in favor of the petitioner. Stop. Such deed has not been executed till date. Stop. The petitioner seeks to submit a comprehensive representation before the concerned authority, annexing all relevant documents, seeking execution of the deed of conveyance, and prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the state respondents submits that who should be the authority to consider? The Special Land Acquisition Officer.
Yes, ma'am.
Yes.
Yes, yes.
The 4th respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation annexing all relevant documents before the 4th respondent within 2 weeks. Within 2 weeks from date. Stop. The fourth respondent is directed to consider and dispose of the representation within 4 weeks from the date of receipt thereof. You get 6
From
weeks
date of
actually.
receiving.
From the date of
Yes,
receipt, 4
yes.
weeks. Thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph, in the event the representation is decided in favor of the petitioner, comma, deed of conveyance be executed in favor of the petitioner within a month thereafter. Disposed of which action?
Grateful to Lordship. Lordship, if law permit, Lordship.
I've stated in accordance with law.
Yes.
Law has to permit, madam. It
Yes.
is your
Yes,
addiction.
Lordship. Yes. Grateful, my lord.
Next.
Instruction.
Right.
Instruction.
The 7th September, when the matter was taken for hearing, my lord, the absence of the other party, my lord, your lordship, was supposed to fix it on 6th December.
Yes, it is appearing as a hearing matter.
If not taken up, my lord, kindly.
It will be called. Please wait. Yes, next matter.
My lord,
Item 5.
item 5, I am appearing for the petitioner, late Mr. Shaptangshu Bas, my lord.
Yes.
My lord, the petitioner before your lordship are trustees of a trust, charitable trust, who are the landlords of a premises in Kashipur, which has been given on rent to the respondent number. Your lordship takes up the respondent number, respondent number 4, my lord. The respondent number the 2, my lord. The chairman, the Central Groundwater Board has been given on rent. This premises was given on rent in 1990 with up to 2007. Rent was agreed. Since 2007, this rent has not been enhanced till date. Now, what has happened in the meantime, my lord, is that initially after 2007, they referred the matter to the CPWD Rent Reassessment Board. They gave a rent certificate. They gave a rent certificate giving a band that the reasonable rent should be in this band. You agree. You enter into negotiation keeping in mind this, my lord. That document, if your lordship takes up their report, the last occasion.
I have already filed a report with the advance copy to the
yes,
state petitioner, but they have not filed any.
But the records are here, my lord. So more or less, all the records are here, which will. My lord, if your lordship kindly first comes to annexure A4, it's probably page 17.
Yes, A4.
My lord, this is being written from their side, the respondent side, to the estate manager. With reference to the first is this letter number such and such dated 6/7/2007, because the lease was expiring on 31st July 2007. With reference to the subject, this office letter cited above, copies enclosed, it is once again requested to expedite furnishing of the required information, that is the fair rent certificate reassessed for our hired office building with effect from 1st August 2007 for a period of 5 years. My lord, if your lordship comes on to page 19. First comes to page 18, the next page. A5.
Yes.
This is being addressed to this is by the Office of the Superintending Engineer, Central PWD, to the Executive Engineer. Rent assessment for accommodation of premises at 5/1 KC Road, your letter number such and such. With reference to your request letter dated number such and such, my lord, it is their request letter. It's not my request letter. Please find enclosed herewith a fair rent certificate in duplicate for taking necessary step, derived rent worked out. This is, lordship, the rent reasonable certificate is the next page. Right, if your lordship takes the second paragraph. First is the reasonable rent of the premises number 5/1 KC Road, Kolkata 2, owned by HON'BLE Charitable Trust and proposed to be hired by the Executive Engineer, Central Groundwater
Water Boards of India has been assessed as per the guideline issued by the Directorate General of Works at Delhi, VDA number such and such, origin number such and such, and the rent as effective from 1st August 2007 works out as hereunder. According to the recognized principle of valuation, that is on the basis of the present value of the property, rupees 5.80 only per month for plinth area excluding municipal taxes. According to prevailing market rate, 6.50 only to 8 super built up area per month, maintenance charges including maintenance charges exclusive municipality. So this is a valuation given by the central government authorities at their request. Now, if your lordship, thereafter your lordship comes to the writ petition, if your lordship kindly comes to page rent assessment certificate, if your lordship comes to P9, my lord, there are a series of meetings minutes where rent is agreed. These are page 65 and 66 of the writ petition.
Yes.
My lord, minutes of meeting for rent negotiation held on such and such. The meeting was held on 23rd August to negotiate rent dated such and such. Now, after negotiation with Mr. Dugar, manager of Messrs. HON'BLE Jaychandlal Gauti Charitable Trust, Kolkata, agreed with the negotiated per month according to including KMC regarding this is for a subsequent period, my lordship. This is now, your lordship, then there is the previous period was held later. After negotiation, your lordship finds rent is negotiated and is agreed. But these are all, they have been in occupation of this premises without enhancement. This is, they are in occupation of the premises without enhancement. Now what happens? They are going on occupying the premises, rent is not been enhanced. Another meeting is held. My lord, the meeting is held on, this meeting is 17th May 2018 at page 69.
69.
69.
Yes.
My lord, this is a situation where no rent has been increased. We are, for 11 years, there has been no enhancement of rent. It is a charitable trust. Expenses are going up. So, the charitable trust is pushed into a corner. Exactly. Now, your lordship kindly comes to the last line before the chart. After vigorous discussions by the executive engineer along with the committee members, the manager of the trust agreed to accept the rent existing building as below. I agreed to the rent suggested by the respondents. It was what was agreed, it was much below what was agreed. I acceded to their reduction proposal. It was their proposal. If your lordship sees, proposed by serial number 2, CGW division XV. So it is not my proposal. My proposal was not accepted. They proposed a rate. Because I was not getting anything enhanced, I agreed to accept this proposal. This is, I agreed to their proposal. It was not my demand, it was their proposal. I agreed. Now, lordship, sometimes if your lordship goes
The last enhancement was in 2012.
2007, my lord.
2007.
Yes. No enhancement, my lord. That was the original. It expired thereafter, no enhancement. They are till today, they are going on paying at the same rate, and it is an admitted position that rate is lower. Now, your lordship kindly sees it is signed by everybody and it is on 17th May 2018.
Yes.
Now, your lordship, sometimes when you go to the market, there is a bargaining going on. The seller says 10 rupees, I say 5 rupees, and the seller agrees. When we go back, we think, why did he agree? It must have been more. That is exactly what has happened.
my lord, তোর করে না
আজকে করেন, আগে তো করতেন
Yes.
So this is exactly the situation what has happened. They have now come up with a proposal saying that it is unreasonable. My demand is, I did not demand, you propose. When you make a proposal, it is presumed that you are authorized to make that proposal. Now they're saying I am not authorized. They're saying Delhi is saying, my lord, if your lordship kindly take some of the letters that has been disclosed in the report, my lord, your lordship, with the lordship's signature.
Yes, yes.
Kindly come to their report. I am relying on their report.
When I point out the pages, that is told by Mr. Bera, because there are 5 or 6 page numbers.
No. Opure number.
Kindly take the report. Kindly come to 40. It's the minute. They have relying on. Understand 40?
Yes, 40.
The meeting was held on 18th and 20th April 2019. But kindly come to, I will not read the entire thing, kindly come to 1. The rates furnished by the land acquisition collector were not acceptable to the landowner. Now they want to show that it was never considered the report of the land acquisition. That was produced, furnished, elaborated, discussed, rejected. There is kindly turn over, kindly turn to 49. This is the report.
Page 69 is related to this. 69 of the writ petition.
That is page 50.
This was on 17th May.
That is the last.
And this is 20th April.
Yes, 20th April. And the consideration of report of the LR is 21st March 2018. The next page, 49.
Yes.
Can you see that? It is written by the government of West Bengal land acquisition collector to executive central government to them. In reference to your office memo number cited above, this is to inform you that the monthly rate of rent per square feet for covered area and use of open land area is as per land department number such. Why we not accepted? There is a ground. Land Acquisition Authority normally use the not reasonable letting value they assess. They assess the land, not the owner.
So we not.
That's why we use that. That has been accepted. Now kindly come to page 50.
Yes.
I am relying only on their report. Meeting was held on 17th May 2018. This was another deliberation. Kindly come to the after the name recorded, the next paragraph starts with Sri A. Kindly come to last. Executive engineer, welcome on the conversation. The manager was informed that the minutes of the meeting was conveyed to the suggestion to the bar. He was informed about the efforts put by this office by exploring the local market and appropriating the various government organization.
Yes, this is annexed to your writ petition.
Yes. Now, I want to show to you Lordship that these they have accepted and now they give it wrong justification of that. That I want to show you.
It was their proposal I accepted.
This is their proposal.
And this was agreed upon by you.
Yes, the rates suggested. Now, how they have agreed? Shall we come to page 58? Now they are saying but it is not sent. It was sent to them. Can you see? Page 51, next page.
58.
51, next page, very next page.
Yes.
The chairman, central orders, it has been sent to them by executive and local authorities. They are trying to now portray the head office is nothing is known to head office, but they themselves have sent this, and that is their disclosure before my.
Yes.
Now can we come to page 58?
$58.
58.
Yes.
Accepted. Yes, it's reasonable.
That is 58. 42. 42 annexure লেখা আছে দেখুন একটা A25 লেখা আছে 29 লেখা আছে পেজ 58 লেখা আছে 42
Well, it may be either 65 or 58
or 42
or 40.
40 is the number. এটা তো
Annexure A46.
Annexure A29.
A29.
Can totally confused.
আমি এই যে দেখাবো না না এটা কবে প্রসিডিং 60 এটা প্রথম যেটা আমাদের এনহ্যান্স রেঞ্জ লেখা
As well as I got
A29 is yes.
Yes. Kindly come to column 11. Though it is old one, all along their proposal accepted and reasonable. Whether the proposed rent is reasonable in the opinion of the head office or it is needs reduction. Yes, reasonable. Now, my lord, kindly come to.
This is on
This is on 16.
14 September 16.
2016. Yes.
Now, my lord, kindly come to
56 টা
66.
66
A54.
New proposal.
New proposal.
A54. A54.
Last year annexure.
A54.
এই তো last.
Yes. Now, my lord, kindly come.
Last.
Kindly come to page 66. Annexure A54. Central groundwater board.
Yes.
Our line. The entity need not be read. Can you come to the last line? If you accept our proposal, kindly convey the same at the earliest for getting approval from higher authority. Please note that payment will be made only after withdrawal of this number suggested, which has been filed by you in the Honorable High Court. This is their proposal. Now, my lord, another document I will show to
proposal.
You are agreeable to this amount?
No.
One
Now, what they say, it is also unreasonable. Well, kindly see who has affirmed this agreement.
It is also proposal. ওটা দেখিয়ে দিন যেগুলো যে ফাইনাল তা নয় মানে অ্যাপ্রুভ নাও হতে পারে এটা দেখিয়ে দিন if you accept the proposal kindly convey to for getting approval এটাও ফাইনাল নয় এখানকার এফিডেভিটটা করেছে হচ্ছে আমাদের ক্লায়েন্ট রিজনাল
Affirmed by
রিজনাল
director. It is not that the
মানে direction is given upon the respondent number 4.
yes, that I want to see.
Yes.
When he himself accepted, when he himself sitting in Calcutta accepted the proposal, said is reasonable. Now can he turn around and say no, it is not? That's why you want to show to Lordship who has affirmed this affidavit. The concerned person who is sitting here and negotiating with us.
একটা জিনিস দেখিয়ে দিই চিঠিটা এই চিঠিটা ওটা না এটা আমাদের এখানে আছে তার ভিতরে এটা দেখুন হ্যাঁ দিল্লি থেকে আসছে দিল্লি থেকে কি চেয়েছে প্রথমে that is in 21
Another letter I want to do Lordship from the writ petition. Page 74.
Page 66 is the last correspondence.
Yes.
This is post filing of the
Post filing. They have said that you conditional withdrawing.
74.
Yes, but they have agreed upon an amount of rupees 1 crore 58 lakhs.
Also no. That is
odd.
accept. No, no.
See the negotiation.
If we
accept our proposal.
So have you accepted this proposal?
No. তারপরে তো how can I go?
Kindly see. Kindly convey the same at the earliest for getting approval from the higher authority.
We are not accepting.
Please note that the payment will be made only after withdrawal of the case. That we are not accepting because my lord is citizen of the matter.
And we are not accepting this rate also. It's much low.
This rate is my lord beyond much lesser than the accepted rate.
Accepted rate possible.
Now, my lord, kindly come to the page 74 of your lordship brief.
There should be a rent agreement between the parties.
It has
Rent agreement is not that a proposal proposed that a committee is to be fixed. We accepted yes or committee proposed, we accepted that.
So no rule regarding enhancement of rent in that agreement?
That's why the committee was formed, at their instance. We agreed to that.
But lease agreement is
Lease agreement কিছু নেই।
lease agreement is there at page 56 of the writ petition.
Kindly come to 74. Government of India is writing to us.
24 কি? আপনারটা?
74, yes.
It's a writ petition. With reference to the subject cited above, it is to inform you that the rent negotiation case of your land at Nasipur, Kolkata is under consideration of such Faridabad as well as in the ministry. Now, CIT Faridabad has sought clarification on the following 2 points. What are the points? The owner has not informed that the payment has to be made along with interest. In view of this submission, it has been assumed that no interest is payable for the enhanced rate and any such matter may not be entertained in future. Action solicited. The issue pertaining to the rent from the period from 1st August 2007 to 31st December 2019 has been negotiated by the committee constituted by the regional director, Kolkata, and it is less than the CPWD assessment rate. However, no clarification has been provided for the rent for the period from such till date or any future cut-off date. This matter has been answered. So it is, they cannot say it is head office was not aware of the fact what is going on.
পরের পদ্ধতিতে উত্তরটা আছে, অপোজিশন উত্তরটা দিয়েছে না, অপোজিশনে অপোজিশনে ওরা এইটাকে উত্তরটাকেও পাঠিয়েছে, সেটা না, সেটা
Our reply is at 75A.
So there is no structure for this enhancement of rent.
So that's why they propose a committee to be formed.
Central government.
Central government proposed a committee to be formed
To decide.
at their instance.
To decide.
Decided.
But there is no structure.
No, decided, accepted. I say it's a concluded contract.
আচ্ছা, এইটা দেখুন, আমাদের রিপ্লাইটা ওরা দিল্লিতে
How can it be a contract? It is not a contract. How can it be a concluded contract?
If your proposal, you proposed, I accepted, your committee decided it, I accepted it.
প্রপোজাল এইটা দেখুন,
Kindly come to 75A. In response to your email, such and such, we would like to say that several times negotiation for rent has been made with your regional office, head office, and also with your ministry, Jal Shakti, but no positive action has been taken. It has been over 13 years since the last revision of rent. The CPWD had already assessed the rent for 2007, 2012, but you failed to implement the assessed rate. So this is at their instance, it has been done. To settle the matter, we had also negotiated with the National Forum Committee, headed by you, but revised rent was not implemented. The above email, you have asked for clarification, the suggestion. We will not charge any interest on outstanding dues if you reimburse the dues on or before 30th November 2021. Any reimbursement after the said date, interest will be charged. The rent negotiated during the committee meeting will remain the same up to 31st July 2022. Further, the rent will be negotiated from 1st August 2022 onwards. So these are the 2 points already crystallizing this issue that I accepted their proposal.
But 21st October.
And I have no other option. Because we are the charitable institute. By this funding, we used to run our show.
এই চিঠিটা ওরা পাঠালো দিল্লিতে, তাতে লাস্টে প্যারাগ্রাফ
57 of the
হ্যাঁ,
This is in reply to 74.
আবার ওটাতে চলে যায়
74. 74 only 2 clarification asked for.
But
Whether
head
it is
office
going to charge interest or what is about the current rate.
but now head office accepts it. This is head office acceptance, central government বসে আছে।
And probably, my lord, this can be construed as an acceptance by the head office. I feel probably lordship may not kindly come to the again to their affidavit at page 57, annex chart A45.
লাস্টে ওটা লিখছে, তাকে লিখছে আপনি ওটা
Yes.
This is the letter dated 28th October 2024. Addressed to under secretary by the ministry. Proposal for lease renewal. In concentration to this in continuation to this office letter number suggestion goes to letters. I which the subject proposal was submitted to the ministry. I am to forward here with a copy of letter dated suggestion received from landlord of the subject building for lease renewal through RT Kolkata's data such and such, by which owner has submitted the following. Then Malad, kindly come to the last. In view of the above, it is requested that as per the subject proposal, approval for lease renewal and enhancement of rent from 84,478 per month to rupees 160.74 per month, effective from 1st August 2007 to 31st July 12, and further to rupees 245 per month will effect from excluding GST, but inclusive of municipal tax and subject building may kindly be accorded. They have accepted everything, all out of they are accepted. When the actual payment comes in, this is this. But I know you'll also be asking about how the leak is maintainable. To that extent, I have to satisfy you also. I'm relying on you guys. 18 and 40. First of all, my lord, I will rely on. I have 1989 1642.
1642.
This is very off-coded judgment. About the action of the government as a landlord or as a tenant. So kindly come to paragraph 15 and 17. This is Soposaji Mukherjee speaking for the Supreme Court, my lord.
Yes.
This court in such and such case had to consider section 4 of the
16.
15 and 17, including 16.
Yes.
Relying on 54 Supreme Court, they said, and so far as material for our present purpose, explain the basis of exemption under section 4 as the government of local authority or the board would not be actuated by any profit-making motive so as to unduly enhance the rate. They are the landlord. I say ratio, as a landlord, as a tenant, you have to act fairly, reasonably. Actuated by any profit-making motive so as to unduly enhance the rent or eject the tenant from their respective properties as private landlords are or likely to be. In other words, the court recognized that the basis of differentiation in favor of the public authority, like the respondent, was on the ground that they would not act for their own purpose as private landlords do, but must act for public purpose. Our attention was drawn by Mr. Since the land council for the applicant to the observation. Statutory power conferred for public purpose is conferred as it were upon trust, not absolutely. That is to say, it can be validly used only in the right and proper way which Parliament is enforcing this one. It therefore follows that the public authorities which enjoy the benefit without being bound by the requirements of the Rent Act must act for public benefit. Hence, to that extent, this is liable to be gone into and can be subject matter of adjudication.
Unable to accept this.
Then number 21. We are unable to accept the submission. Being a public body, even in respect of his dealing with his tenant, it must act in a public interest, and an instruction of that duty is amenable to examination either in civil suit or in this jurisdiction.
They are the land. Tenants,
Just ratio is different. They are the landlord, they are the tenant. Then my lord,
2021.
2021, 13 I am not repeating because what party has been followed in so many judgments. I try to associate with the current.
2021.
13
Page go to
121.
Yes, paragraph.
Then the BPCL was the land tenant. So kindly come to paragraph 29.
In 29.
spite of their internal correspondence, they were not relinquishing. Like this, head office says you relinquish the position. They are not doing it. The Supreme Court observing in a writ petition. As observed by the High Court, the conduct of respondent number 1 DPCL in continuing with the acquisition of the state premises without paying any rent from such and such is unbecoming of a statutory corporation, which is a state within the meaning of Article 2 of the Constitution. We therefore find that while directing respondent to vacate, this is a consequential order. So even as a tenant, you cannot act as a private tenant. Then a suit will be filed, will stretch for years together.
Market.
We postpone the issue of determination of market rent for a period of 3 weeks from today. The appellant is available to respondent shall be filed the written submission 30.2 years. Respondent BPCL is directed to pay arrears of market rent to the appellant suggested till the date of handing over possession. That is a penal consequence because they are not legally. Yet that squarely may not apply, but the stand of the tenant, being a public Article 12 authority, how to be dealt with, my lord, this judgment, and starting with Dwarkadas Marpatia has decided that.
Company দেখিয়ে দিয়েছে এখানে দেখিয়ে দিয়েছে না 2007-6 এটা দেখো এনেছে বুকটা ওইটাও এসছে
That's all your submission?
Only 2007-6 Supreme Court cases, page 81. Paragraph 13 and 16.
Page.
Yes, paragraph
13.
13, 1-3.
13. The appellant company is a state within the meaning of Article 12 of the Constitution of India. It is therefore enjoyed with a duty to act fairly and reasonably. Just because it has been conferred with a statutory power, the same by itself would not mean that exercise of thereof in any manner whatsoever will meet the requirements of law. Then 16. An executive action must be informed by reason. An unfair executive action can only survive of the potent reason. An action which is simply unfair or unreasonable would not sustain. Objective satisfaction must be of the basis for an executive action. Even subjective satisfaction on the part of the state is liable to a judicial review. The state, acting whether as a landlord or a tenant, is required to act bona fide and not arbitrarily when the same is likely to affect the right of others. It is well squarely in my.
আচ্ছা ওরা যে আরেকটা জিনিস দেখিয়ে দিন ওরা যে রেটটা অফার করেছে দ্যাট রেট দ্যাট ওয়াজ এক্সপ্রেসলি রিজেক্টেড বাই মি না সেটা দেখিয়ে দিন না সেটা দেখে নিন না একটু
নেই আমরা তো
না সেটা রিজেক্ট করে একটু দেখিয়ে দিন না ওরা
Do you want to go through these judgments and come back?
My lord, the judgments, as you lordship pleases. Otherwise, factual aspect, I have answers, my lord. Other than those judgments, on factual subject, I have the answers.
Will you come back immediately after vacation? Let him go through these.
If he no problem reply. If I not there, he will be given. That depends upon Mr. Ban. Let them pay some money. We are not run the show. It's a voluntary organization, charitable organization.
We are facing criminal charges because of this.
And
That's the problem.
and they're
Yes.
My lord, on factual aspect, I can answer today, and the rest, my lord, the judgments, I can the next day, my lord.
Please do not make it piecemeal.
Let them
Then, my
pay
lord, next
let
day.
them pay some amount without prejudice to us.
We are paying, my lord, regularly without any fault. We are paying that.
7
And
amount you are paying.
yes,
according to
and we are agreeable to pay, my lord, because, my lord,
But
if your lordship can,
which amount?
we are, my lord, that amount has been referred by my senior counsel, my lord.
Please tell me. Let them pay the admitted amount. I'll deal with the matter.
yes.
Which is that? What is the admitted amount that you are ready to pay?
Page 67.
The last
Last page of the his report.
Not only that, lordship kindly sees, I have at page 8 of my my lord report, they are asking exorbitant amount.
1 crore 58 lakhs. And or this is your agreeable amount?
At page 66.
Page 71. That's the last page of your report.
But they are rejected that, I think.
We have rejected, yes.
What is the admitted?
It is also informed that this office has roughly worked out the area rent payable, etc. in premises for an amount of 1,58,24,422, including all taxes, as specified in the legal agreement.
This is the admitted amount.
Yes, I think so.
Pay this within 7 days.
My lord,
Come back.
my lord, I have to approve from the Delhi. My lord, can for 2 weeks, my lord.
You'll pay this within 2 weeks, right?
Without prejudice to a contention, because this rate is, my lord, only this
The matter
rate.
will be kept pending. I'm not deciding on the matter.
Lordship.
Let the admitted
What they are claiming is exorbitant.
I am not.
And I have documents to
we'll
show
deal
that.
with it. We'll deal with it.
Lordship.
We'll deal with it.
Lordship.
Writ petition will remain pending. Please, since you are admitting this amount, you are agreeable
Yes,
to pay this amount.
that later I have annexed it admits, my lord.
Heard learned counsel for the petitioner. The paragraph. The petitioner complains that petitioners. Complain that the second respondent, the respondent authorities took rent of the premises in question by virtue of a lease agreement dated March 16, 1997, initially for a period of 5 years, which was extended from time to time.
It was never extended. Never extended.
It was of 1997.
1997.
But the lease was from 2002 to 2007.
It was not formally extended.
And thereafter, from 2007, it was not extended. Rent was not.
For an initial period of 5 years. Stop. The lease was granted from 2002 to 2007.
Yes. 31st July 2007.
After the lease was granted from 2002 to 31st July 2007, after which it was not formally extended. They are continuing in possession.
Yes.
The lease rent has not been enhanced after 2007, despite several communications made by and between the parties in this regard. Stop. Paragraph. Learned counsel for the respondents submits that the respondents are agreeable to pay rupees 1,58,24,422. 158,24,422.
Till March.
As per annexure A54.
March 2023.
As area rents from August 2007 to March 2023. Stop. The said amount is disputed by the petitioners who submit that the amount is far less than the market value of the property.
The agreed rent.
Far less than the rent agreed upon by the parties.
Okay.
Paragraph. Let the matter appear under the same heading on 17th January. The admitted rent will be deposited within 2 weeks. 17 January 2024. Paragraph. Since the respondent authorities have agreed to pay rupees 158,24,422 to the petitioner as area rents, the said amount be paid to the petitioners by the who is to pay the amount? Respondent number 2, the chairman.
My lord, it has to come from, my lord, ministry.
From the?
From the ministry, my lord, not from here, not from West Bengal authority.
You have
It
agreed to pay
directly,
this amount, so who will be responsible? I'll record that you can pay this amount within 2 weeks.
by the authorities, my lord. I shall consider, I shall ask with them who will
No, that has to be put, because lordship, the letter also says approval. This is admitted, now they'll say I am not approved.
কি বললাম আমরা?
So direct them to pay money.
ওটা কেটে দিন, ওই সিন্স থেকে কেটে দিন। Learned counsel for the respondents submits না, এটা কেটে দিন। Since the respondent authorities have agreed to pay the amount of rupees such and such as area rents, comma, the said amount is directed to be paid to the petitioners by the respondent authorities within 2 weeks from date. Yes?
Without
Paragraph. This order is passed without passed without prejudice to the rights and contentions of the parties.
will appear under the same.
Yes? पहले फैल हमारा लेखा है next
Item number 6. 6.
yes petitioner
For the state.
anyone for the petitioner item number 6 anyone for the petitioner no one none appears for the petitioner no accommodation is sought monthly list of January he was present on the earlier date also
Yes, ma'am.
let the matter appear under the same heading in the monthly list of January 2024
January 24.
Item number 7.
My lord, I'm appearing for respondent number 3, my lord. The writ petitioners had completed their arguments. I had started, my lord. The time did not permit. So my lord had kept it on the next date. Thereafter, it was taken up last in September, my lord.
yes
My lord, I am ready to continue with my arguments, my lord. My lord, will kindly take the
so they is appearing in this letter.
and Mr. Kishore Datta was appearing for. My lord will kindly recall, this is a writ petition, my lord, principally asking for a declaration. My lord will kindly take the prayers of the writ petition, which is at page 24. Prayer A, my lord, page 24.
Yes, yes.
A declaration be passed declaring the petrol pump situated at such and such did not vest either under the Calcutta Thika Tenancy Acquisition Regulation Act 1981 or under the West Bengal Thika Tenancy Act 2001, my lord. So first prayer is a declaration, my lord. Thereafter, prayer B is a right to renew or to purchase, my lord. Kindly come to prayer D is a writ in the nature of mandamus due issue upon the respondent number 3, thereby directing them to hand over the vacant and khas possession of such and such square feet situated at such and such. And prayer E, my lord will kindly take a writ in the nature of mandamus due issue directing the respondent number 3 to pay occupation charges at the market rate, my lord. My lord, our first humble submission on the last date was, my lord, that prayer A, a declaration whether a particular land is Thika land or not, my lord, that has to be decided by the tribunal Land Reforms Tribunal, my lord. The West Bengal, constituted under the West Bengal Land Reforms Tenancy Tribunal Act of 1997, my lord. In this regard, my lord, I had placed the sections of the, my lord has a copy of the Land Reforms Act. I'll just take my lord through it because West Bengal Land Reforms and Tenancy Tribunal Act 1997, my lord.
Tenancy Tribunal.
You have copy, ache Shubhika dao. My lord, we have a copy.
Do you have a spare copy?
Shubhika dao.
Land Reforms Act, Land Reforms and Tenancy Tribunal.
Tenancy Tribunal.
Section 4.
No, I want to show.
Laws, West Bengal laws guloর মধ্যে থাকবে। ওই land laws
এর পরে আনছি।
land laws
last time judge কে। My lord.
Yes. Yes.
My lord, the first section we wanted to place, my lord, is the definition section. 2R, my lord. I'm obliged, my lord. 2R lists out the specified acts, my lord. Under this specified act, my lord, the Calcutta Thika Tenancy Act is included, my lord. This is of 1981. I don't know whether my lord's book refers to the new Thika Tenancy Act, which has been included by way of amendment, my lord. Then my lord will kindly take section 6 of this act.
By now, this is settled law.
Yes, my lord. Yes. So, my lord, the tribunal has the jurisdiction to deal with matters of the specified act, my lord. Under 7, under 6, the jurisdiction has been vested with the tribunal, my lord. Section 6. Under section 7, my lord, the power which was with the writ court under Article 226 has been taken away, save and except the division bench's power under 226 and that of Supreme Court, my lord. And that is, the exclusion is also mentioned in section 8. For this, my lord, we had relied upon a division bench judgment of this honorable court in Anchit Agrawal. My lord, we had placed paragraph 4, which listed the prayer which was there before the division bench in that matter, which is exactly the same as the prayer before my lord today. My lord will kindly look at paragraph 4 at page 3. In the year 2005, a writ petition was filed. Last line of that paragraph 4 is prayer A of the said writ petition reads as follow. A declaration be issued by High Court that premises number such and such does not come within the purview of the 2001 Act and does not stand vested, my lord. In this context, it was considering. Now, kindly come to paragraph 15 of this judgment. Arguments were made only on lack of jurisdiction, not on the merits as to whether it is a Thika land or not. Paragraph 15, the appellant has assailed the order of the learned single judge on the sole ground that the learned single judge lacked jurisdiction to entertain the writ petition on which the impugned order was passed. No argument was advanced by the appellant on the merits of the case as to whether or not the writ petitioner was entitled to an order in terms of prayer A of the writ petition. Learned advocate for the writ petitioner tried to justify the impugned order on merits. We are not inclined to, nor do we find it necessary to go into the merit of the writ petitioner's claim, since we are of the view that the learned judge did not have the jurisdiction to entertain the writ petition for the reasons indicated hereinafter. My lord will kindly take paragraph 23 after this. Paragraph 23 is at page 16, my lord. Yes. My lord, initially when the writ petition was filed, there was prayer A to H. But when the writ petition was being finally heard, they abandoned all the other prayer and continued only with prayer A, which was a declaration that this is not a Thika land, my lord. Para 23. What indisputably follows from the above discussion is that for adjudication of any dispute which touches any provisions of specified act, one must approach the tribunal at the first instance, and for all other civil courts, including High Court, excepting Division Bench, exercising jurisdiction under Articles 226, 227 of the Constitution, have lost the power and jurisdiction to entertain such dispute. The prayers are listed, the initial prayers. My Lord will kindly come to para 25 at page 20.
Yes.
After the court lists that all the other prayers were abandoned, perhaps in a para 25, perhaps in a desperate attempt to save the writ petition from being thrown out at the threshold on the ground of want of High Court's jurisdiction, the writ petitioner abandoned all the prayers except prayer A. However, in our view, the learned single judge did not have jurisdiction even to adjudicate the issue as to whether or not the premises in question stood or stands vested in the state of West Bengal under the 1981 Act or under the 2001 Act, since such adjudication would also touch the provisions of the specified Act. It was argued on behalf of the writ petitioner, para 26, my lord, that that the decision in Jatadhari and Lokhiamani Dasi had made it clear that the land on which the petrol pump operates is not a Thika land and does not come within the purview of either the 1981 Act or the 2001 Act. However, this is an argument on merits. The tribunal has exclusive jurisdiction to decide after considering the nature and character of the property in question and the decision governing the field whether or not the writ petitioner's property is a Thika property or not. My lord, thereafter, the appeal was allowed and the writ petition, my lord, which was earlier allowed, was not entertained, my lord. My lord, the writ petitioners before my lord have made the same prayer and they have relied on Jatadhari, Lokhiamani Dashi, and also on Nimai Chandra, which is a recent Supreme Court judgment, my lord, which all approves Jatadhari and Lokhiamani Dashi. We are on the same stage today, my lord, as in before the division bench in Anchit Agrawal case. The issue whether, because of these three judgments, which say that whether or not a retail outlet is a Thika land or not, has to be decided by the tribunal, my lord. My lord, the second prayer, which is prayer D for vacant possession and prayer E for occupational charges, my lord, those questions, my lord, my humble submission is should be decided only after my lord comes to a conclusion who has the determination to deal with this land, my lord. If the tribunal has the determination, my lord, if my lord holds that prayer A, my lord, will not grant, my lord, then the matter has to go before the tribunal, who will then consider prayer vacant possession.
But this issue be decided first.
My lord, my lord. So,
So,
my lord, I'm not making any submissions on
merits.
prayer D and E on merits, my lord. And my lord, one more aspect, I have, in this matter, my lord, the earlier a writ petition was filed by Indian Oil Corporation, my lord, when the virus to the 1981 Thika Tenancy Act was challenged. In that writ petition, my learned friend's client, the writ petitioner was respondent number 30, my lord. After the formation of the Tribunal Act, my lord, the writ petition was transferred to the tribunal. And my lord, orders have been passed in that writ petition, my lord. May I just place that order? The writ petition itself refers to page 10, my lord. Will kindly take page 10 of the instant writ petition, my lord. Page 10, para 10. This is the writ petition, my lord, which was filed by respondent number 3, which is Indian Oil Corporation, in the year 1983, challenging the virus of the regulation rules, my lord. In this, my lord, an interim order was passed, which is at page 45.
yes.
kindly consider page 46. The respondent herein and their servants and agents, including the state, shall not take any steps in any way interfere with the possession, use, and enjoyment of the concerned premises by the petitioner corporation, nor will the transfer or dispose of the said premises. The parties shall also not take any steps for renewal or extension of lease during the pendency of the rule, my lord. My lord,
This was prior to the act.
yes, my lord. I'm just that this land was subject matter of writ, my lord. That writ has been transferred to the tribunal, my lord. And that order is at next page, page 47. Learned counsel appearing for the writ petitioner submitted that this writ petition should be relegated to the Land Reforms Tenancy Tribunal Act without expressing any opinion as regards the legality of the submission made by the learned counsel. There shall be an order as prayed for. The department is directed to remit the records of the aforesaid tribunal for disposal in accordance with law. And then, my lord, next page, it says that page 48, ad interim order already passed on 28th November shall not prevent either of the parties to this writ petition for taking steps in accordance with law, my lord. My lord, so my humble submission is prayer A, my lord will kindly not entertain. My lord, even though my learned friend has made submissions on the merits, my learned senior friend has submitted that a writ petition can be filed for entertaining a prayer for eviction and for occupational charges. And in that regard, he has cited 3 judgments also. If my lord's desire is that I should not make any submissions on merit, otherwise I'm willing, ready to
maintainability point be flashed out.
my lord. So I'm not giving an answer to the merits which has been argued by my learned senior friend, my lord. He had cited Dolidas High Court, Orissa. He had cited Dolidas Supreme Court. He had cited delayed judgment of my lord. 3 judgments, my lord.
Yes, on the maintainability point only.
Yes.
Before that, Mr. Do you want to add that? Has covered the entire point, yes.
But primarily 2 things were on the maintainability part. First is whether IOCL, in view of their conduct, can today raise the point of alternative forum. Number 1. And number 2 is whether a writ petition with such a prayer is maintainable or not. These are 2 fundamental prayers. Law today is well settled, it was sometimes in the middle, it was it became somewhat vulnerable. Again, the previous law has been reiterated by the Supreme Court. Therefore, Lokshmani Dashi, Jotadhar, and all those judgments today they again operate in the field. Now, so far as the previous round of litigation is concerned, please come back to paragraph number 9, which my learned friend has placed before my lord. Paragraph 9 at page 8.
Yes.
Petitioner states that upon promulgation of the said Act of 1981, IOCL, now this is very important, IOCL claimed that the land comprising in the petrol pump stood vested in the state of West Bengal under the provisions of so and so. In such circumstances, Sitikona Mitra filed a writ petition number, etc. before this honorable court, praying for the following reliefs. A writ in the nature of mandamus to show cause why so-and-so act should not be declared as ultra vires and void, and alternatively, in any event, inapplicable to premises number, etc. Then mandamus do issue commanding the respondent to desist from or forbearing from taking steps in furtherance to so-and-so act. Then C, mandamus to forthwith recall the letters dated so-and-so, issued by the respondent number 5, rule 9I, etc. Now, that is, at a stage where IOCL was claiming this is a Thika tenanted property. Today, IOCL had changed stands. Kindly take, this letter at page 103.
which is one of, part of the cause of action of this writ petition.
How do you justify your first prayer?
Yes, I'll come to that.
You are somehow going into the merits of the case.
So far as kindly see what
Have
is
you asked for a declaration that this property doesn't is not a thika property?
yes.
How can this court grant such declaration?
There are two things, my lord. First is what is being suggested before the court today is that I go and make this same prayer A or an ancillary prayers before the tribunal.
Yes.
Therefore, my lord, what is being suggested that I go before the tribunal and seek a declaration that you don't have any jurisdiction. But a prayer
has to decide first.
Yes. Now the tribunal, my lord, will decide provided it falls within, my lord, one of the specified acts. My lord, the language of the legislation is that if a dispute falls within the specified act, go before the tribunal. My lord, today, my lord, the law is that petrol pumps are not thika tenanted property. Therefore, the application of the specified act is, or the question of application of the specified act does not arise. Therefore, I need not go before the tribunal and pray for a declaration that this is not a thika tenanted property, and so you decide that you don't have jurisdiction, because the first prayer I have to go and make over there is that you don't have any jurisdiction.
They have to first decide whether the property is thika property. Have you seen this division bench judgment?
My lord, I've seen the division bench judgment. I'll consider it and come back, because
it is exactly on this issue.
my lord, the division bench judgment, with respect, my lord, cannot, my lord, override, my lord, a Supreme Court judgment. Law of precedent says that if I go before an honorable single judge, relying upon one or two Supreme Court judgments, irrespective of, my lord, the strength of the
Supreme Court judgments have also been taken into consideration in this judgment.
Therefore, my lord, if the Supreme Court judgments have been taken into consideration in this judgment, and if I can demonstrate before my lord that, my lord, what should I say, the basis on which the Honorable Supreme Court had delivered these judgments, my lord, has not been considered by this court. I'll give you, my lord, the indicators. On the last occasion, my lord, I have given, is that what was the object of acquisition of these natural resources. Where the object was, this has not been considered. In Dolly Das's case, which, my lord, the Orissa High Court was dealing, the object of the SOP was to ensure that the ownership of these properties go to these public sector or these bodies. And number two is regulation of natural resources. This was the object. Now, keeping this object in mind, my lord, initially the Orissa High Court had held it, and my lord, then, my lord, this was affirmed by the Honorable Supreme Court. Now, when I am a public authority, my birth or the reason of my birth, my lord, has to be taken into consideration. Therefore, my lord, there is a digression. Why this digression? That in normal cases, you have to go under the normal landlord-tenant acts, or, my lord, the rent acts, my lord, as they call it, and get your issues decided, get an eviction decree throughout the person who is in possession. But when and which is, my lord, not, my lord, rent oriented or tenancy oriented, then, my lord, you have to incorporate those or inculcate those in the decision making process and then take a decision. When you take over the resources, you do it by a legislative fiat.
It's again kind of on merit.
Yes, I'll again, my lord, place those judgments, but first,
the judgment in Dolly Das and the ones which you have referred,
yes,
they stand on the anvil that the properties are not thika properties.
Yes.
Right, but in this case, you've prayed for a declaration that the property is not thika property.
Now, my lord, as your lordship know, my lord, then what is a declaration? Declaration.
The court cannot give such a declaration.
I'll tell you, lordship. I'll come back, my lord, if required. What is a declaration? The declaration is a status which is already prevailing. or a state of affairs which is already prevailing.
Has to be adjudged.
Yes, I'll tell you. Now, my lord, this judging, is it dependent on any disputed questions of fact? My respectful submission is no. Nobody disputes that I have let it out. Nobody disputes that it was let out for a retail outlet. Nobody disputes that a retail outlet is still operating. There is no dispute. Now the question is that the mere submission or mere filing of returns before the TICA controller under the misconception of law, will it make it a TICA tenanted property?
This has to be decided by the tribunal.
Now this, my lord, with respect, my lord, has to be decided by the writ court in the background of the law settled. Otherwise, my lord, I have to go and make a negative prayer.
No, the tribunal has to give a declaration as to whether this is TICA property. If it is, the tribunal has jurisdiction. If not, the tribunal will release it. Simple. But this declaration has to be given by the tribunal, not the writ court.
I'll come back on that. Yes, I'll come back on that.
It's really a pat on the point, this judgment.
But I'll distinguish that judgment of the basic intention or the basic purpose why a writ court could be invoked. Jurisdiction of the writ court could be invoked in this situation. But I understand, my lord, the
Time of AC, I'm not really convinced. So please come back.
But I had, my lord, occasion to, my lord, refer through a honorable single judge distinguishing a division bench matter and sending it to the larger bench. In that case, my lord, I'll come back with, my lord, summoned on jurisprudence. Because finally, my lord, if there is a contradiction, of course, I have to demonstrate that contradiction.
I don't think.
Yes.
Anyway, come back.
Yes.
My lord, only one thing I had forgotten to place. We have already filed an application under Section 5, subsection 3 of the TICA Tenancy Act before the TICA controller, whether the land is TICA or not, my lord.
Where are the documents?
This is the application which is pending, and they have already filed a suit for eviction. And
to come back with a supplementary report,
my lord, I'll put
annexing these documents.
My lord, I will do it, my lord.
What is this one?
Application under 5.3.
Who will make it?
No, by my client.
For declaration of the same property as TICA property before the TICA tenant.
Yes,
Before
yes.
the tribunal.
It's
Because
pending, my lord.
but I'll tell you, Lord, my learned friend, I don't remember whether she was appearing or not, but there is a division bench judgment of Justice Indira Banerjee saying that if you say that the TICA Act does not apply, you need not go over there. Otherwise, when I go and say,
you don't, in the other matters,
Yeah.
it is decided that the TICA Act doesn't apply. But
Yes.
here you've asked for a declaration to that effect.
Millard,
That's the difficulty.
Now, Millard, I'll tell you, Lordship, this declaration is sought for in view of the law, which has already been settled. Take an example where I delete my prayer A. Because I delete my prayer A and say that grant me an eviction decree. Then I need not go over there.
Please think over. Because such a declaration is sought before the tribunal, as learned
Yes,
counsel
my lord.
says,
Yes,
and that's pending. So if the tribunal says yes and the writ court says no, it's a conflict of decisions. Please come back.
My lord, their suit for eviction and mean profit is also pending.
Before the tribunal.
No, before the suit, city civil.
But these are all disclosed.
With regard to the same property.
Yes, my lord. They have disclosed it, my lord.
We have disclosed it.
My learned senior friend.
But
they
why I have
disclosed
come over here is because of the change of stand of the petition. I'm sorry, IOCL at page 103. Now he is asking for a fresh lease from me. Therefore, the IOCL has also given up that point that this is a TICA tenanted property. Otherwise, why will they come back to me and ask for a fresh lease?
Please come.
Yes.
Learned counsel for the respondents challenge the maintainability of the writ petition on the ground that the matter pertains to the West Bengal TICA tenancy within bracket acquisition and regulation bracket closed Act 2001 and has to be dealt with by the Land Reforms and Tenancy Tribunal. Paragraph. On prayer of the petitioner, the matter is adjourned. এটা করে learned counsel for the petitioner denies and disputes such contention of the respondents. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18 January.
18 January.
Will it be my Lord's pleasure that my learned friend has made submissions on merits? I have not answered because my Lord said
Yes, I have
Yes,
referred
yes,
to
yes.
only maintainability. And you want to come back with an on prayer of the your respondent number?
Respondent number 3, my Lord.
On prayer of the third on prayer of the third respondent, liberty is granted to use a supplementary report annexing relevant documents.
My Lord, grateful.
Please serve an advance copy.
My Lord, I will.
You can take back your book.
Grateful.
Next.
I'm grateful. Ma'am.
January. 18 January.
Next.
Yes, please. Calling from mentioned matter, item number 524. 524.
524 mala, I'm for the petition one.
Yes.
What happened, mala? This mala, the previously mala, the application was moved. There was a direction, mala. Mala, may I have granted leave to mala
Have you served the Jela Parishad?
supplement? Yes, mala.
Jela Parishad, Panchayat Samiti, you serve all of them.
Yes, mala. Affidavit of mala, may I granted leave to mala file supplementary affidavit, mala. Mala, what happened after filing of this application? Mala, they have passed the mala, the video passed the mala final order. That was not annexed in the writ application.
Final order, my lord, already all the things.
Yes.
Direction is there, my lord, only to comply the direction. You can actually see the last para of the last para, my lord. Last para of page 1.
What was the matter about?
Mala matter, mala, my petitioner's land was mala taken mala for the purpose of construction of road without any proceedings. Mala, initially mala I made objection. Thereafter mala moved the writ application. Mala, that order has been annexed in the writ application. Mala, there was a direction upon the mala block development officer to consider and mala dispose of and take a decision. Mala, while mala after communication of that mala order, the hearing was taken several times, but my lord, no order was communicated. Then my lord, challenging that inaction, my lord, I made the representation, and then my lord, I filed a present writ application, my lord, against the inaction of the my lord video to pass the final order. Well, after during pendency, after filing present writ application and service of the copy of the writ application, the present the order has been communicated, where it has been already.
So the Pradhan was directed to implement within 2 weeks. That is over.
Yes, yes, my lord.
So let the Pradhan be directed to implement within 1 month.
Yes, yes, my lord, that only the.
Yes. But Pradhan is not appearing.
My lord,
Please serve a copy of the order. Affidavit of service. None appears for the Uttar Dinajpur Jela Parishad and the Kaliaganj Panchayat Samiti. None appears for respondent numbers 2, 3, 7, and 10, despite service. Paragraph supplementary affidavit used by the petitioner is taken on record. Paragraph. In an earlier petition, there was a direction.
Yes, yes, kindly have a look, my lord, the page 41, 40, my lord, in the writ application, my lord.
40.
40, my lord.
The order?
Yes, yes, my lord, order, copy of the order, my lord. Considering the submission as advanced by the learned advocate for the parties.
Yes, yes. Paragraph. The petitioner submits that his land has been utilized for construction of a village road.
Yes, yes, ma'am.
Village road without acquiring the same by due process of law. Stop. Pursuant to an earlier writ petition filed by the petitioner, being WP 7392
of 2018.
pursuant to an earlier pursuant to an order passed by this court in an earlier writ petition being WP 7392 within bracket W of 2018 on 2nd July 2019, directing the block development officer Kaliaganj Development Block, District Uttar Dinajpur to consider the representation submitted by the petitioner and take a decision within a stipulated time frame, the block development officer, by an order passed on 30th August 2022, disposed of the said representation with the following observation. A supplementary affidavit, page 5. Is studying earliest. Mark portion. Studying earliest. Paragraph. Unfortunately, the said direction has not been complied with as yet. Stop. The petitioner prays for a direction upon the Pradhan, Dhan Coil, DHANKOIL, -2, normal 2, Arabic 2, Gram Panchayat, being the 10th respondent herein, to implement the said order at the earliest. Paragraph. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since the block development officer has directed the 10th respondent to comply with the order dated 30th August 2022 within a stipulated time frame which has already expired, the 10th respondent be directed to implement the said order within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of? আমি fold করে রেখেছি ওই পাতাটা। Yes, next.
Item number 525.
Yes. Petitioner? Anyone for the petitioner? None appears for the petitioner. No accommodation is sought. Dismiss for default.
Item number 526.
I'm for the petition.
I am appearing on behalf of the private respondents. Lordship, no copy has been served on me, Lordship.
Because
Copy not served.
my lord, it appears from the track report that it was attempted to be served, but it came back with the endorsement insufficient address.
Please serve a copy.
Yes, my lord, then kindly fix it any day, my lord. Give me 2 days time. I'm serving her by the course of the day, my lord.
What is the matter about?
My lord, challenging a notice issued under section 4C of the Land Reforms Act, my lord,
But it ought to have been issued by the collector, but it has been issued by the BLRO. The complaint is, my lord, against my client,
You're challenging a 4C notice.
my lord.
How is this court?
My lord, it's a refugee land, my lord.
Yes.
It's a refugee land, my lord.
That notice cannot be dealt with by this court.
My lord, it is not a normal case, my lord. It is a land allotted by, under the rehabilitation scheme by the government, my lord. And my lord, inherent lack of jurisdiction, my lord.
Where is your prayer? The notice dated 30th May. Please show me the notice.
56 page.
Yes, Mr. Butterbell. 4C notice.
4C notice is into another
Page 56 is a notarial certificate. Where is the notice?
Page 30th of May 2023, my lord, page 56.
Lord,
56 is a notarial certificate.
My lord,
30th May 55.
55.
This is clearly the Land Reforms Act. This court cannot deal with it.
Well, this land belongs to the refugee.
The tribunal will deal with it.
My lord, in that case, my lord, I will be praying for one indulgence, my lord. Kindly gives me 10 days time to prefer the appeal, my lord. In the meantime, let them not invoke this, because
The court doesn't have jurisdiction at all. The court cannot pass.
my lord, what they are doing, my lord, during the pendency of this writ petition, my lord, they are issued another notice suppressing the first one. They are trying to frustrate my challenge to the notice, my lord.
So here there is a direction for restoration of the land.
I understand, my lord.
Coercive action is there in
My
the
lord,
notice.
my lord, they are issuing.
Immediately.
My lord, they are issuing a second notice without referring to the first, so that my writ petition or whatever my challenge is become infractious, my lord.
Doesn't become infractious. Why? How does it become infractious?
My lord, they are
There is no threat of removal or demolition, anything.
not yet.
You have only been asked to, yes, so file in the meantime. I'll grant you liberty.
My lord.
Withdraw, file,
Very well.
approach the appropriate forum.
Very well.
The matter pertains to the West Bengal Land Reforms Act 1955. Paragraph, the petitioner seeks to withdraw the writ petition and file and take necessary steps before the appropriate forum. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall however be no arrest to costs as in certified website. Great, next.
But the affidavit service may be kept to the record.
Affidavit of service.
Five hundred 527.
We appear for the state, my lord.
This matter relates to unauthorized enforcement of government land.
Have you served the private
Yes,
servants?
yes, they have received.
They've received?
সঙ্গে আছে দিদা
Yes.
The petitioners are the recorded.
PWD land. PWD land.
No, government land.
Government land.
The petitioner is the recorded owner of land with building, and the private respondent made unauthorized enforcement on the government land. The petitioner raised complaint but took no steps. Thereafter, the petitioner moved before this honorable court. The honorable court passed an order, directed the petitioner to make an application before the subdivisional officer, who will take decision. Subdivisional officer took decision and found, yes, there is an enforcement. Lord, kindly come to page 25, order of the subdivisional officer.
27.
Page 27. Annexure P3. Order dated 18th September 2019.
Yes, further steps have not been taken.
No.
That is your.
Yes. Thereafter, due to inaction to take steps, the petitioner made application. That is page 31 and 32. And after that, the subdivisional officer wrote a letter to the concerned officer, inspector in charge, Kolimpur Police Station. That is at page 33. You are requested to look into the matter and take necessary action, but no action has yet been taken.
My lord, what I gather, my lord, I am yet to receive an instructions from them, my lord. What I gather from this brief, my lord, that assailing this order, the private respondent had filed a writ petition before this honorable court, which was subsequently dismissed for default, as for this record. My lord, this application, what my learned senior friend's client has made, and pursuant to that, the subdivisional officer referring to the police authorities, my lord, I see, my lord, no proceeding on the section 5 of this act, my lord. What it is transpiring from the record, my lord, kindly directs, my lord, for
Within
section 5 proceeding should be initiated, if not initiated.
encroachment has to be removed.
Yes, my lord. Section 5 is absolutely clear on it, my lord. My lord, kindly, my lord, observe that if not initiated, my lord. I do not know why I don't have the instruction in this regard.
Direction for removal.
Yes.
Because again, if there's a direction for initiation,
Yes,
it will be carried
No,
out.
they have the the subdivisional officer has found out. The subdivision officer has found out. It's observed.
Yes.
Page 27.
What are they waiting for? Affidavit of service. Paragraph none appears for the private respondents despite service. Paragraph. Pursuant to an earlier writ petition, pursuant to an order passed by this court, in an earlier writ petition, comma, the subdivisional magistrate, comma, Tehotto, comma, Nodia, comma, by an order passed on 18th September 2019, comma, recorded that encroachment upon public land was made by the private respondents herein. Stop. The subdivisional magistrate directed the encroachers to remove such encroachment and vacate the land in question within 15 days from the date of communication of the order. Stop. The encroachment was not removed by the private respondents, comma, nor any further steps taken by the respondent authorities in this regard. Stop. The petitioner submitted representations before the subdivisional officer Tehotto
23rd March 2023.
on 23rd March 2023 and 27th February 20 on 27th February 2023 and 23rd March 2023 respectively, requesting implementation of the order pursuant to which the subdivisional officer, comma, Tehotto, comma, by a letter issued on 31st May 2023 to the inspector in charge, comma, Kolimpur Police Station, comma, Nodia, requested necessary action. Stop. No further steps have been taken. Paragraph, upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that since encroachment upon government land by the private respondents has been detected by the subdivisional magistrate and an order passed to that effect on 18th September 2019, comma, who should implement the order?
My lord, the subdivisional officer himself, my lord.
The subdivisional officer, comma, being the third respondent herein, be directed to implement the said order in its true letter and spirit within 2 weeks from the date of communication of this order. Paragraph. Disposed of. No further hearing is necessary.
No, man.
It has-
It's section 5 is clear, absolutely. The police authorities may be
Yes.
note further directions also be needed.
Nothing is required.
Grateful, man.
Then come
Next.
528.
Lamp for the petition. It's my petition. Sorry. The what happened, my lord?
Respondents?
My lord, the all are state respondents. My lord, notice has been served, my lord.
No one appearing?
My lord, all my lord, super my instruction, my lord, they have already received, my lord, the notice.
Mr. De, may I request you? Please serve a copy to Mr. De.
Then, my
Yes, what is the matter about?
matter, my lord, just to my lord, the there is my lord Khasmohan land. My lord, in the year 1950, my lord, the some portion of the my lord, around the Howrah court premises. My lord, 1950 initially some part of its stall, my lord, given license my lord, to me, to my predecessor. My lord, the rest portion of that stall, my lord, given in 1966. My lord, in favor of this petition number predecessor interest of the petition number 2. Malad, since then, Malad, the predecessor were running the stall. Malad, now, Malad, we are the petitioners are running the stall. Malad, in the year, what happened in the year, Malad, 2011-12, Malad, some portion, some stall holder was Malad issued some notice, Malad, to for eviction of the Malad that some stall, Malad, they surrendered their position. Malad, that notice was Malad under challenge before this honorable court. Malad, kindly have a look, Malad, the order passed by this honorable court. On that writ application. Malad, the where Malad it has specifically observed Malad, the notice is Malad at page 40. Malad, the previous
Granted license by the government.
yes, Malad, by the government. Malad, the notice of Malad annexure P6 at page 40. Malad, the notice of that Malad, that writ application. Malad, this notice was challenged. Malad, kindly have a look. Malad,
yes.
That was challenge. Next page, the order passed by this honorable court. Where it was specifically observed, suit is the only remedy for recovery of possession. Kindly have a look. Page 45 is the second paragraph of the third paragraph. Be that is made, the where it is specifically observed. The suit is the only remedy to recover the possession of the if I have not paid the license fee or
yes.
Since then, the no steps, there was a leave was granted to the authorities to take steps in accordance with law. Fourth paragraph. This order will not preclude the state respondents from recovering the possession. Since then, no steps was taken till today. What happened in the last September 18, 2 persons came in my stall and threatened orally threatened without issuing any notice or nothing else. Thereafter, they verbally instructed. They by 1st October that I have specifically pleaded in my application.
So no notice was served.
No notice was served. They have claiming they are the officers of the respondents. Can have a look page paragraph 9 onwards, 11 paragraph 10 onwards. Paragraph 10 I have specifically pleaded. On 18th September, 2 persons came to the stall of the petitioner claiming themselves the representative of the respondent number 2 and verbally directed the petitioner to vacate their stall. Since then, thereafter again oral threat was giving the no notice, nothing, no suit, no proceedings. This is the predicament, but that's why the presented application the
whether the petition is maintainable. Nothing is there, only averment. And only for averment, there is a specific order was there.
Yes, one of the
taking. So why not this
petition is premature.
No, no, well, I will specifically pleaded, I say, by oath, my lord, I have, by oath, my lord, I have still let them, that recording be made, my lord, they have not taken any steps, my lord, against me, my lord, or.
My lord, your lordship, there is a specific order is there.
Yes, yes, my lord, I have annexed that one.
In other petitioners,
In
not
other
this
petition, my lord, not in my petition.
My petition.
Yes, my lord.
That is in respect of other petitioners.
Yes, my lord.
There a notice was served.
Huh.
And that was quashed.
That was caused, my lord, but here, my lord, no notice was passed.
His possession should not be disturbed
Disturbed,
without
that's
process of law.
Yes, yes, my lord.
Yes, my lord, without taking any recourse.
Yes, yes, my lord, only that.
Affidavit of service. None appears for the respondents despite service. Mr. Their service regularized. The petitioners submit that their predecessors in interest were granted license in respect of the plot in question.
Stall in question, or stall.
Respect of
stall.
One stall or two stalls?
Yes, yes, one stall.
In
One
respect
stall
of
or two
the
persons, my lord.
Stall in question by the government, and the petitioners are at present running their business from the said stall as legal heirs of the original licensees. The petitioners were threatened by the respondent. The petitioners were verbally directed to vacate the said stalls by the respondent authorities, who threatened to evict them therefrom without taking recourse to due process of law. Paragraph. Learned counsel for the petitioners has taken this court to an earlier writ petition being AST 254 of 2012, wherein a notice issued upon the licensees was challenged by an order passed on 26 September 2012, a coordinate bench of this court held that possession could not be recovered from the licensee after termination of license without taking recourse to law. The learned court further held that recovery of possession from lessees or licensees was not permissible otherwise than by way of suit. Paragraph. It prima facie appears that the petitioners are licensees in respect of the stall in question. Stop. No notice of eviction appears to have been served upon them by the respondents. Paragraph. In view of the above, this court is inclined to hold that since the petitioners appear to be in possession of the property in question as licensees, they can be evicted therefrom only by taking recourse to law. Paragraph. The writ petition is accordingly disposed of, directing the respondent authorities not to disturb the peaceful possession of the petitioners in respect of the stall in question without due course of law. Paragraph. However, the respondent authorities are at liberty to however, this order shall not preclude the respondents from recovering possession of the stall in question from the petitioners by due process of law. Disposed of which?
Bhagwat 529. Yes.
Yes.
117 petitioners is before your lordship.
Mr. Dey is appearing.
Yes, Lord. I have given notice to Mr.
Is it only the same?
Only the state, madam.
Yes.
Madam, this is an identical issue.
You serve the panchayat.
Perhaps not Ponchas is not the necessary party, my lord, if your lordship can
I'll expunge. You want to expunge the name?
necessarily, madam. Because in the
You
notice,
either expunge the name or serve. Two options. You have made them party. Panchayat
why,
Samiti,
if your
you have not even served.
before that, my lord, page 148, why I have made party to the point.
First thing, you have to either expunge their names or you have to serve them. It's your choice.
No lordship, I will explain.
You'll expunge. The Panchayat Samiti, Pradhan,
Yes.
Gram Panchayat, they are not necessary parties.
Well, in that even I'll serve and come back.
I think you have not even made an attempt to serve.
No, madam.
You have only served the state.
Because
Please
the
serve them and
identical,
come.
actually identical issue has been decided by my lord with a direction upon the respondent number 5. My lord will kindly turns to page. Why, page 164.
But that can be done only after service, isn't it? 164.
164.
That is 164 is the order, man.
Yes.
Your lordship will see the previous এটা কত যেটা
Page 148, the relevant
148
portion,
my lord, your lordship
wherein
will
the
see
authority has
the
held
resolution.
that mistaken the land has been utilized for the purpose of development of the
Panchayat is the requiring body. They have utilized the
No.
land.
My lord,
the
Panchayat
irrigation
present in
department
the
is the
resolution.
respondent number
Yes.
5.
My lord, everybody is necessary, man.
My lord,
Panchayat,
in the meeting held on in 2016, the Pradhan of the concerned Gram Panchayat was present. My lord will get the same from my lord,
my lord, they are the
page 149.
Please serve and come.
As you like. Only in the legal lordship, would it be
Since-
possible to keep before the vacation?
No.
Because the issue
Come back
has-
immediately after vacation. Since all the respondents, since service upon all the respondents is not complete, comma, let the matter stand over till 8 January.
8 January.
Next.
530.
I appear on the petitioner, lordship. Only state respondent.
My lord, claiming amount already been paid, my lord. Petitioner.
Lordship, in respect of my instruction, in respect of plot number 410 has not been paid. 410.
এটা এইভাবে দিতে হয়।
Yes, my lord, 410 already been paid. Lot number.
একটু তাড়াতাড়ি দিতে হবে। স্লো হলে হবে না।
June.
What is the date?
2020?
দিয়েছে কবে দিয়েছে 2022 লর্ডশিপ
Yes, plot number 410.
410
Last column, my lord. First
Has been-
page, last column. Plot number.
How is the payment done? Deposited in the
My lord,
account?
electronics, my lord, electronics.
So account deposit.
Account deposit.
Yes.
Then my lord,
Have you served a copy to?
lordship,
Yes, ma'am.
just
Yes,
now.
ma'am.
Then my lord, dispose of recording that.
Status affidavit of service filed by the petitioner and status report submitted on behalf of the state respondents are taken on behalf of the respondents, shall we state, are taken on record. Paragraph. The petitioner has prayed for a direction upon the respondent authorities to pay compensation in respect of the land acquisition, in respect of the land in question involved in the land acquisition proceeding being LA case number 4/29 of 2012-2013 with regard to plot number 410, Mouja Dulbari Devipur, DULBRI, Devipur, jail number 158. Which was utilized for construction of
Paragraph 4, lordship.
Isla affected Sundarban embankment in 2009. Paragraph. It appears from the status report submitted by the state respondents that compensation as sought in the writ petition has already been paid on
20th June 2022 by electronic mode, ma'am. True.
Payment.
This is a 23 writ petition.
Lordship.
You are not aware of this payment.
My instruction is not, sir, I am not aware.
Has already been paid to the petitioner. Paragraph in view of the above, nothing further remains to be adjudicated in the writ petition and the same is accordingly disposed of. There shall, however, be no order as to costs or agenda certified website. No, paid. Stop. Next.
Item number 531.
I appear with the petition, lordship.
I'm appearing for the statement.
Matter relating to my lord, unauthorized construction by the private respondent constructed a club house in front of my dwelling house. Lordship, I made representation, that is page.
Lord, I appear for the private respondent.
Yes.
Lord, before
Page
opening the
25.
case, I have certain objections in this regard, my lord. My lord, the petitioner has not come before this honorable court with clean hands because of on the self-same cause of action previous occasion, my lord, one separate writ application was filed. That has not been mentioned here. The petitioner is not the owner of the property, my lord. And number two, my lord, against the club authority, they raised an allegation, but the club authority has not been made party with the writ petition.
I made secretary as a party, lordship.
And number three is, my lord, the dwelling house has been constructed over the property, over the land of an agricultural land.
No, lord.
That has not been converted. It appears, your lordship may kindly have a look, my lord. That is at page, my lord, page 24.
You have filed the writ petition against an individual, Gopal Chandra Mondal.
Lordship, Gopal
Not
Chandra
in
is
the
secretary.
capacity of
Yes.
stated that he is the
Grateful to
secretary.
your lord. Secretary, lordship, I
Where is
stated.
that stated?
Allegation is against the secretary and the president and the club authority.
Page 9, lordship.
Page?
9, lordship. Page 4, paragraph 9. In my representation, I also stated, lordship.
He has to be impleaded in the capacity of the secretary.
Page 26, my representation, lordship, I have stated.
False title of the writ petition. You have impleaded him in his individual capacity.
Lordship.
Then, how?
Lordship, kindly, lordship can direct the authority to consider my. I have stated in my representation that the Gopal Chandra Mondal is the secretary of the club, lordship. Page 26, lordship.
Make necessary corrections in the cause title.
Lordship.
Yes, I'll grant you liberty.
Lordship.
And my lord, the self-same cause of action, previous occasion.
Where is the document?
Lordship, self-same cause of action have the husband of the petitioner filed the writ petition under Act 64, Lordship. The authority concerned intimated the petitioner the 64. 64.
Which
PWD
Act?
land.
64?
PWD land.
1964, Vegetable Highways Act, yes.
The authority concerned intimated that the land was not belonging to the PWD land. Thereafter, wife of the petitioner made fresh representation before the SDO, Lordship.
This is the 62 Act.
Which is a 62 Act.
So it's a different act altogether.
My lord, and third thing, my lord, that is they have constructed the dwelling house on the agricultural land without making any conversion. Whether they have
you taken any steps for that?
my
That is
lord,
not subject matter of this writ petition.
the land was converted, Lord. Right. It's
The
true.
subject matter is only encroachment by your client.
It's true, my lord.
Yes.
And the subject
And the
matter
court
is
cannot decide titles.
yes.
If
My lord,
you
I'm grateful
agree,
to your lordship, my lord.
Let us do one thing. Let the authority decide. This court will not go into
But
matters.
the allegation is, your lordship may kindly have a look, that for which free ingress and egress is seriously affected. My humble submission is before your lordship that
That is not affected. Can you occupy government land?
no. I am not occupying his neither the
You're
front
not
side.
occupying his land. You're occupying government land. That is the allegation.
Yes, my lord. That's true, my lord. There is a hut chala. That is the club premises. It's a chala.
On
Hut.
government land, right?
Yes, my lord. That's true. No doubt.
So please make your
But as to whether it may be directed that as to whether free ingress and egress, their allegation is whether affected or not, my lord.
free ingress allegation is secondary. What is primarily to be considered is whether there is any encroachment on government land.
Grateful, Lord.
Why is this free ingress part included? So that it doesn't become a public interest litigation.
My lord, this is grateful to your lordship, but my lord, this
Where
is
representation.
page. My lord,
I understand your concern, sir, but then let the authority decide.
page 25, lordship.
I understand your concern since it's an encroachment and a club.
Page 25.
Let the authority decide.
Let the authority decide, my lord. It is village area. There is a huge land, my lord. The club is constructed on that, the government plot in everywhere, my lord. And it is not that actually what is his allegation that actually not is being jeopardized or not is being affected.
Let him not be jeopardized. The government is being jeopardized. That cannot continue.
Government has not made any allegation against me.
Affidavit
There is
of
no
service.
allegation of the government against me, my lord.
The petitioner claims to be the record. Where is your ownership document? This is the deed.
Record of rights I have also annexed, lordship. Page 24 is the record.
Owner of the
Page
plot is
24.
and submits that the private respondent on prayer of the petitioner, liberty is granted to correct the cause title of the writ petition. তারপরে কোন কি বললাম and submits respondent একজন has encroached upon a portion of government land adjoining her property, thereby obstructing her egress and ingress. The petitioner submitted a representation in this regard before the concerned authority on 4th September 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the private respondent submits that though there is a club on the plot in dispute, of which the private respondent is the secretary, the egress and ingress of the petitioner is not affected by the said construction.
Grateful to you.
Stop. Secondly, a similar writ petition was filed by the petitioner earlier, which was disposed of by this court. Stop. Third Thirdly, the petitioner has raised construction in the plot in dispute without applying for conversion of the same. These are your three objections. Paragraph. With regard to the first objection raised by the private respondent, this court is inclined to hold that since it has been admitted by this respondent that a clubhouse stands on the plot in dispute, illegal encroachment upon government land is in fact admitted by the private respondent, and whether such encroachment obstructs the egress and ingress of the petitioner is only secondary. Stop. Such encroachment is required to be removed by the concerned authority under the West Bengal Public Land within bracket Eviction of Unauthorized Occupants bracket closed Act 1962. Paragraph. Secondly, in reply to the submission made on behalf of the private respondent, learned counsel for the petitioner submits that an earlier writ petition was filed by the husband of the petitioner under the West Bengal Highways Act 1964, alleging unauthorized encroachment of PWD land. Stop. The authority, upon the suit was disposed of, stop. Upon disposal of the said writ petition, the concerned government authority said that the land did not fall within the purview of, the land was not PWD land and therefore did not fall within the purview of the 1964 Act. Stop. Hence, the present writ petition has been filed. Paragraph. Thirdly, this court, in exercise of extraordinary jurisdiction under Article 226 of the Constitution of India, cannot deal with the issue of conversion as raised by the private respondent. Stop. The private respondent is at liberty to agitate the said issue before the appropriate forum. Paragraph. Learned counsel for the state respondents submits that the third respondent should deal with it. Sub-divisional officer. The third respondent be directed to deal with the representation submitted by the petitioner in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 2 months. 2 months sufficient? Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, disposed of.
Grateful, Your Lordship.
আগে অ্যাপ্লিকেশনটা হোক তারপর।
ও আচ্ছা অ্যাপ্লিকেশন
Yes, call the list.
আইটেম নাম্বার 538 530
My lord, from 538 to 543, my lord. They are all, my lord, e-rickshaw matters. Your lordship has, my lord, already dealt with similar thing. Do not wish to, my lord, trouble your lordship with that. If your lordship will straight away come to page 155.
There's a CAN application.
Yes, CAN application, my learned friend has filed, my lord. My lord, I'll be very frank with, that's why I referred to 155. My lord, we are not going to stand in the way of my learned friend being added as a party.
So let this be allowed.
Yes, that can be allowed. Your lordship will go through page 155. That's the last order, my lord, passed in respect of a similar place where my learned friend had filed an application, my lord, for being added as a party respondent, my lord. And
My lord, writs may be allowed on the similar terms.
yes, all the on similar.
I haven't seen. Can I see your?
Send a copy to me.
Yes, served it on mail.
You are there in this.
Disposed
Which order is included here?
My lord. My lord, the three terms, rule 1 to 6, the three terms were mentioned, my lord.
They're all mean.
The amended term as per 18 to order of HON'BLE 86.
Yes, that's
all
it.
are mentioned.
All are there, my lord.
Page 158, my lord, there is the bill.
Same on page 155 আছে ক্যানটা আপনি করবেন কেন ক্যান ছিল So you will be added as respondent number.
Respondent number.
এখানে 6 আছে
ভাই
কেন respondent number 5
তোকে তো মেল করা হয়েছে
ঠিকানাটা
মেল করা হয়েছে
তোমার ঠিকানাটা अवेलेबल না আস্তে আস্তে
respondent कितना है
5 होगा 5 बोलिए 5
respondent number 5, my lord.
the director transport directorate is respondent number 3 here also it's 3
Yes, ma'am.
so the same order
Same, it's the same.
Municipality 158
No, this has been clarified, my lord. Mr. Amol Sen
has vehemently argued with regard to passing of the order against the registering authority, and your lordship is of the view that will cause problems. That's why your lordship has been pleased to direct the director.
The same order is being.
Same order, my lord, which will serve the purpose.
155. I'll just call them one by one.
Yes, one by one.
My lord, order is on the registering authority, on the director, no.
Same.
No, 155 director. Please read it.
Yeah.
सब में same है sir. Respondent number 5 हो. हाँ? सब में
sir.
Can
Data बोल रही है.
same order.
Oh, हाँ, director.
आगे can disclose ना affidavit of service शुरू तो नहीं. उठा करके चेक करता है. वो तो मैं देख. Yes, next.
My lord, all the respondents are respondent number 5. It will be added as respondent.
All one by one.
Yes, sure.
Otherwise, there may be a mistake.
Very good. As your lordship.
Stop. And
give me this. Take it to
These are under the heading application, I think. Application application to dispose of photo. Therefore, by consent of the parties, the writ petition is treated as on days list and taken up for consideration. It would apply the respondent number. Added as respondent number 5. Yes, next.
540. So also, my lord, respondent number 5 would.
You are not appearing. That's why I propose to call them. Who is appearing? Mr. P. Bondopadhyay. Who is he? He's not in the panel now. So may I request you to appear? It an writ petition to the government, none appears for the respondent number 5. Can you respondent number 5 should add? WPA none appears for the state respondents. Mr. Debra, who is presented for regular respondent. I'll regularize your appointment.
along with the junior.
Along with the junior of his choice. Please serve a copy to Mr. Debra.
Certainly. Yes.
Yes, next.
540. Pobha Motors.
There are no affidavits of service in these matters, the remaining matters.
My lord, we are admitting the service.
Not
necessary.
খালি প্রথমটাতে একটা আছে বোধহয় হ্যাঁ বাকিগুলোতে নেই কিন্তু affidavit of service. Yes, 541.
541.
You are appearing.
Service করে দিও তুমি আমাকে পাবে না বন্ধু
Khushbu, which is the next type?
नहीं तो सुमित मेरे हाथ में ये सुमित मेरे हाथ में है सर respondent number 5 same
Same.
Next
542.
542 Mr. Debra
542.
542 ये একটা কোন রেগুলারাইজ number 5 same 543
543.
Yeah.
Same on.
Same. Great.
All disposed of.
All the matters are disposed of. Great.
Next. Can or restriction be passed?
Item number 544 for the petitioner, my lord. Yes, my lord. Grateful, my lord. Lordship has enlisted the matter in the supplementary list today morning, which I have taken the leave. Lordship, that have challenged the appellate authority's order, which was communicated to me over on the weekends. Now, my lord, I have served upon the department today itself, indicating that the matter will be taken up today at 2 p.m. But if my learned friend has not received any copy, then in that case,
He needs to take instructions also.
the Lordship will kindly see the appellate authority's order. Lordship, it's crossed the limit of arbitrariness. My lord, when the matter is sub judice, Lordship will kindly come to page 85 of the second writ petition.
My lord, in this matter, my lord, probably this matter is filed today. And anyhow or somehow that is matter is also listed. And
Yes, similar matter.
yes, my lord, copy is also served upon the office of the respondent. My lord, what is happening nowadays? My lord, railway has no power to engage the council. My lord, railway will send the, after receiving the copy of the writ petition, they will send the matter to the Ministry of Law and Justice. And Ministry of Law and Justice will engage advocate from their listed panel. So, my lord, I think, my lord, today they are, after receiving, same may be sent or maybe will be sent in course of the day. And I think, my lord, let the matter may be taken up at least tomorrow, my lord. Otherwise, it is very difficult. And my lord, I cannot directly receive this brief. As because, my lord, the MOL. Yes, my lord.
Actually, only one aspect I will say.
If, my lord, what will happen if any adverse will order will pass? My lord, they will think, my lord, that I have.
I understand your
Yes, my lord.
Because only, Lordship, only my respectful submission to this is this: only after serving upon the department, my lord, department has been notified that the Lordship matter will be taken up today at 2 p.m. Now,
be done in a day, Mr.
now, my lord, I'm not. No, I'm not on that, my
This is a
lord.
department.
Only thing is this: as because my learned friend is appearing in another matter which is connected with this, and where the appellate authority has already rejected my appeal, and Sam has been communicated to me in this weekend. So, my lord, the time was the factor and the essence. Now, my lord, that Lordship compelled me to come up with this fresh writ application because, my lord, it's a lightning speed, my lord. Because, or else, Lordship will remember, Lordship, my learned friend junior who was appearing on that day, Lordship made an assurance that they will not going to at least open the tender. Because if that be so, third party will come and say that I have accrued a right over that. In that event, if my writ petition subsequently succeeds, then in that event also I will be deprived from the fruits of litigation. If it is succeeds, thereafter, they are carrying the assurance has been carried that there will be no opening of the tender prejudicing my right.
My lord,
in that case, your Lordship wants to take up this matter tomorrow, Lordship. I am not standing on the way, Lordship. If that be taken up day after tomorrow, also I have no other issues. Only thing is this, my lord, the tender which is going to be opened today, Lordship, let it
my lord,
be
already opened my instruction.
This is the approach.
There was an assurance by your junior before this court that it will not be open.
My lord, I have.
The court cannot rely on you at all.
Yes, Lordship, they'll let the judicial order in that case, my lord.
Yes.
My lord, I have asked, my lord, that person. Actually, on that day, I was not here, my lord, due to, my lord, the resolution of the Bar Association. I have asked him, my lord, I have seen, my lord, he is also appearing virtually, my lord. My lord, he told me that I shall not such consent was given. That was.
It's not given, the court request.
That is his statement. My lord, I don't know what your statement actually he made on that day.
I told your lordship that I am not in position to give any, until unless I get an instruction from the railway authorities, I cannot give any assurance. But still, since your lordship was insisting upon, I told him, okay, let's see how it can be worked out. That's what I've told.
It's not a
My lord, assuming, my lord, for a sake of argument, my lord, assume that he consent was given. My lord, in that case also, my lord,
it's not consent, my lord.
Kindly consider one thing. Whether one learned advocate is appearing by filing a vokalatnama, my lord, whether he has any right to give any consent on behalf of his client without having any written instruction. My lord, if that is be so, my lord, that consent will be treated as a no consent. My lord, at least, my lord, 5 decisions I know, and my lord, particularly on that point, my lord, I argued in another court.
Third party interest.
Yes, my lord.
Otherwise, the writ petition becomes.
Yes, my lord. Grateful, my lord.
So, my lord, that already, my lord, that I think, my lord, when the tender is open, my lord, he was also liberty to participate in the tender process.
If I participate, my right grows.
Yes, my lord.
Right
as soon as he choose not to participate in the tender process, He has no right, my lord.
Lordship, my respectful
challenge that.
submission is this.
There is
Lordship will
no.
see-
Where is the letter dated 8th December 2020?
Lordship, this is at page.
There is no embargo, my lord, upon him
Page
to not to participate in the tender process.
85. Lordship, kindly see page 85, annexure P9. No reason, nothing.
Have you seen this order? This is ridiculous.
Before the terminating.
Oh, my lord, just now I have instructed the tender. Yes, my lord, tender was
Lordship,
open.
kindly see how they
And
have.
my lord, he was also not participated in the
I
tender.
do not participate.
Yes. My lord,
I will
if
not
there is no such embargo, my lord, if there is no such embargo to participate in the tender process, he choose not to participate in the tender process, and without, my lord, participating in the tender process, my lord, how can he
I have
challenge the
challenged
tender
the
process? my lord?
tender. I have challenged the tender. If I participate, then my challenge goes.
Yes, my lord.
Without
Yes.
participation.
Kindly see, my lord. Just now, my lord, I have received that.
And if there is a note regard.
Mr. Roy, when the court speaks for you, please do not make this submission.
And my lord, the at present bid is much more in
What
more
does this mean? The bidding through e-auction
yes.
has been closed by 11:20 hours on 11th, that is today, and finalized as rejected. What does this mean?
Finalized.
Please finalized as rejected. Please come to the last line.
My lord,
And he's supposed
yes,
to
my lord. The
who doesn't want
highest bid rate is, my lord, 44,990.
Sir, the letter that you have shown to
Yes,
me.
ma'am.
Please come. What does
Yes.
this mean?
It is
With my very little knowledge of English, I do not follow this.
my lord, 40 minutes, so that I
Yes.
can take.
The bid has been closed and finalized as rejected. So
it
the
is
bid
money
is
taking.
rejected. Ridiculous.
Tender process to cancel. Oh, no, my lord. That all the, my lord, the price quoted in the tender, that is the below reserve price. For this, in the entire tender process is cancelled, rejected.
That's it.
My lord, may I?
Record this.
I will say only one thing, my lord.
And my lord, when the next tender will, my lord, floated, he can, my lord,
Well, kindly see
participate.
this. Kindly see
That's
this.
a different issue.
Kindly see this, my lord.
Let me record that the tender has been rejected.
Now, my lord, one thing, my lord.
Yes.
If you kindly come to page 28 of my first writ petition, the quote which I have given is 53,666. Now, Lordship will kindly see, it is not the economic reason. It's a punitive reason.
I'm not going into merits at all.
Then in that case, my lord.
Since the tender has been, is no longer there for the time being.
Yes.
There is no question of an interim order now.
They have discharged the tender.
Yes.
Lordship, they record that. They have discharged the tender.
I'll deal with the first matter first.
Yes, and my lord, kindly kept with the record also, my lord, that instruction, my lord.
No, Lordship, kindly come to the first matter. Or recording the order.
First matter is 27279.
Yes, my lord. This is where I have challenged the termination and also the issuance of the tender. So far as the tender parties goes, my lord, that gets discharged.
Record
Instruction submitted on written instruction submitted on behalf of the railway authorities is taken on record. Paragraph learned counsel for the railway authorities submits that upon opening of the e-auction, it was found that none of the bidders complied with the terms of the tender.
Yes, ma'am. Inter process, inter tender process is due to, my lord,
the term of the tender, and as such, the entire tender has been cancelled.
my lord, due to non-receiving the, my lord, the reserve price.
Oh, it's submitted on behalf of the upon opening of the submits that the entire tender has been cancelled due to non-receipt of the reserve price.
Yes.
Due to non-receipt of the reserve price. In that case, after vacation. No hurry.
No, Lordship, one aspect is this, my lord, the so far as the my prayer, so far as the staying of the
When-
term, just a minute, আমি শেষ করি, তারপর তুমি বলো. So far as my challenge remains with regard to the termination, my lord.
The notice
I was beheaded, my lord, on the basis
in this is the first application.
my first application, which has been served upon them.
Nothing further remains in the first application.
No, first application, my lord, I have challenged the termination along with issuance of tender. That issuance of tender prayer portion will become infructuous after this, my lord. And so far as the first part is concerned, that the termination, I have challenged it, that challenge remains. That challenge is still open because it has been issued in contravention to the Railway Board circular, which says that there has to be 3 overloadings for termination of
Now,
contract.
pursuant to such challenge,
Yes.
the second petition comes in.
Second writ petition, I have challenged the appellate authorities order, my lord,
That is with regard to
confirming the termination.
the same thing here.
Because termination, my lord, has
Order stayed. Because it's not a reasoned order. at
yes,
all.
yes.
Have you seen this order? It's
Order of the appellate authority.
Just
My lord-
rejected, my lord.
My lord, which is challenged in the second writ petition. My lord, I have no instruction and I have no knowledge regarding this matter. As because, my lord, I am not appearing and I have already, my lord, submission before your lordship, that may have served upon the office of the railway. And the railway, my lord, at present, my lord, has no authority to engage.
Instructions. I'll record.
My lord, I am not appearing. So how? I am not opening my
Kindly
mouth.
stay the appellate authorities order.
My lord, only my submission is this, my
Second
lord.
matter, my lord, appellate authorities order, lordship has seen. It's not today, tomorrow. Tomorrow. Okay, great. So in that case, my lord, officers are there, if I can serve, so that
No, my lord, I cannot, my lord. That MOL will engage, my lord, the advocate.
if they do not
See, not an authority. That happens with the state also. You're
Yes.
tomorrow, my lord, tomorrow.
Will you be ready by tomorrow?
My lord, tomorrow.
Second matter.
My lord, second matter, my lord, I am not engaged, my lord, till date. My lord, that will be engaged by the Ministry of Law and Justice.
Service, Mr. Roy. Then only it can be taken up. Second matter.
Then in that case, my lord, take it on Wednesday, my lord. I think 48 hours notice will be there.
You can be ready with the affidavit of service?
Yes, yes.
Day after tomorrow?
Yes, my lord. As your lordship so desires.
The first matter is shifted to the other side of the vacation.
In first matter, my lord, I am appearing.
If the
Let
appellate
the matter appear under the same heading.
তাহলে best হচ্ছে দুটো my lord, better, my lord,
both the matters
both
will be
the
heard.
matter will be taken up.
Let this be shifted. I'll deal with the other matter on the next
Yes.
date. Just remind me of this date. কি বললাম লাস্ট নাইটে বলুন ওই যে ক্যান্সেল তো হ্যাঁ এটা প্যারা করুন
তবে এটা সত্যি মানে এটা নমস্কার তোমাদের
paragraph let the matter appear under the same heading
that is virtually possible মানে এটা কি
19th
করে
January
করলে আমি জানি না
2024.
Lordship, the second writ petition
First matter. Second one, it will appear
tomorrow, my lord, and the day after tomorrow.
Wednesday.
And my lord, may I submit one thing, my lord? Let both the matter, my lord, may be taken up, my lord.
So
Any day, any day.
stay this matter without
Yes,
your
yes,
consent?
yes.
Without
No, my lord. In that case, my lord, I am ready, my lord. I am ready.
Second matter.
Second matter.
Have to be taken up together.
No, my lord. Second matter, I am not. My lord.
Second matter, will you be ready by Wednesday or shall I fix it on Friday?
No, my lord. My lord. Second matter, my lord. I have submitted, my lord. That may have served, my lord.
Said that, but they have served. They have to come back with an affidavit of service.
Yes, my lord.
Friday. Please be ready with your affidavit of service. Let us see if Mr. Ghosh receives instruction by
Anyway, so far as the first matter is concerned, lordship stays the termination notice, my lord, at least 19th January.
Why, my lord?
That has been affirmed in the second matter.
Termination.
I follow.
The second matter.
Okay. Okay, I follow.
Termination notice against that appellate authority order that has been challenged. So I think, my lord, that first matter is already infractuous. Anyhow, my lord, that is my submission.
It is because the appellate authority's order has already been challenged. So let us see. Please come back on Friday.
Friday.
A supplementary এটা করে এটা হচ্ছে 27787 এটা না
অর্ডারটা দেখি আনান এই ফ্রাইডে পাবো
The learned counsel for the petitioner submits that copy of the writ petition along with annexure thereto have has been served upon the respondent this day. Paragraph, let the matter appear under the same heading on Friday 15th December 2024. Paragraph affidavit of service be submitted on the agenda date.
Lordship, with your kind permission.
দিয়ে দিন ওর নাম।
Keep trying. Lot to dash it.
Your Lordship, I'm appearing on behalf of the petitioner and I'm praying for not today, Your Lordship.
To the other side of the petition.
I am for the.
On prayer of the petitioner, the matter is adjourned.
And Your Lordship,
Fine.
Lordship, I further pray to fix the matter on the next week because my senior is currently not in this city right now.
Not possible, sir. No further dates will be granted on this side of the vacation if you miss a date now. 22nd January. Let the matter appear under the same.
Usual order only to হয়ে যেত। My lord, my learned friend is
not ready.
My lord, here in respondents are ready, the petitioner is not ready.
Not today.
The person who is filing the writ.
Not today. You'll
Yes.
come back tomorrow.
Yes, Lordship.
He accept it.
Not today.
Your Lordship, I'm praying for fix the matter on next week, Your Lordship, because my senior is currently not in the.
If the petitioner is not interested, can't help. 22nd January 2024.
Great.
I offered a not today. That also he's not ready, so can't help. Next.
546. My lord, I beg to appear on behalf of the petitioner, madam.
Yes.
My lord, this is the supplementary affidavit. My lord, the crux of the matter relates to the bus. My lord, the petitioner has purchased a bus from one Birendra Pratap Singh.
From a?
Birendra Pratap Singh. This Birendra Pratap Singh has purchased it from Canara Bank. The Canara Bank.
Auction.
To auction.
Through e-auction.
E-auction. Initially, it was purchased by Mr. Joy Shaw. Mr. Joy Shaw failed to pay the EMIs and subsequently it was handed over to Canara Bank and Mr. Joy Shaw has duly signed the document stating that, okay, I have got no objection if the bus is handed over to Canara Bank. From Canara Bank through e-auction, Mr. Birendra Pratap Singh became the owner.
Who is appearing for Joy?
I gather
You're appearing. Yes.
After this matter was, Birendra Pratap Singh took the bus. Mr. Shivuram Maiti, the present petitioner, took the bus from Mr. Birendra Pratap Singh. Now, my lord, on a very first instance, my lord, kindly comes to the annexure P1.
Oh, 156.3 was filed by the private respondent?
Absolutely.
And the vehicle taken away from you?
Lordship. Absolutely. My lord, now there is another, my lord has directed how the vehicle came to Joy Shaw. That becomes a very interesting part because 156 clause 3 was directed by one of the coordinate bench of this court. You file a 156 clause 3. That 156 clause 3 was filed. Now, in this 156 clause 3, there was a direction. Suppressing the material facts. My lord, this is a supplementary affidavit. On the date order, my lord will get it from the 5/8/2022.
At page?
My lord, it's an order sheet, my lord. I gather it's page 7.
Certified copy?
Certified copy.
Yes, order sheets. Order dated?
5/8/2022.
Five eight or 5/5?
I gather it's 5/8.
It's towards the end of the.
My lord, this is peruse the report of the IO. My lord, just will I find it for your lordship? The last starting.
I find a 5-5 order. 5th May order. 5th
No, my lord. It's my page 7, I gather. But I'll find it for your lordship now.
Page 7, yes.
My lord has got it, the last paragraph. But kindly see the date only, my lord. What order has been passed? Has been passed. 5/8/2022.
Yes.
It appears the vehicle in question has been auctioned by the bank. However, it appears that the de facto complainant is the recorded registered owner of the vehicle in question, as on date none else has claimed the vehicle since seizure. In view of these circumstances, as per the Surendrabhai Amalabhai Desai, Gujarat 2023, the Honorable Court observed, and as per this, 20 lakhs have been directed to return the vehicle. Now, my lord, kindly see. This procedural latches on my writ petition has been, they themselves have given on the 21st of July 2022 to rectify it. That has been not been done. But in my writ petition, my lord, annexure P1.
Annexure?
P1. By the RTO.
তারপরে সাবমিট করে নিতে সুবিধা হবে
Yes. So it is still recorded in the name of Joshua.
The bank themselves stated that it was still, it should be rectified. It is unintended lattice. They have admitted it. That is not a fact. But taking advantage of this, they have taken it. Now, they are applying it also.
Yes.
Lordship, the primary order of your Lordship, passed dated 19th of July 2023, is a self-explanatory of the observation on the primary day of your Lordship, where your Lordship understood the matter, ceasing of the matter, and passed this order. It's a exhaustive order, Lordship. Lordship, the petitioner claims to have purchased the vehicle in question from 6th respondent, who in turn purchased the vehicle through e-auction floated by bank. Being the third respondent herein, due to non-payment of dues by the 4th respondent in terms of the hypothecation agreement entered into by and between the bank and the 4th respondent in respect of the said vehicle. The primary grievance of the 4th respondent is the vehicle was snatched away from him without serving a notice upon him. It appears that 4th respondent filed a writ petition being WPA so-and-so in this court, and by an order passed on so-and-so, a coordinate bench of this court observed that since the recovery agents had seized the vehicle midway without notice upon the petitioner therein, the petitioner, respondent number 4, in the present writ petition was granted liberty to initiate appropriate proceedings after ascertaining facts under section 156 clause 3 of the Code of Criminal Procedure. Learned counsel for the 4th respondent submits that such proceeding was initiated by him in compliance of the order of the court, and the vehicle in question was returned to him by an order of the learned additional chief judicial magistrate Alipur in proceeding pending before him. Learned counsel for the bank seeks to take instruction as to whether notice was served upon the 4th respondent before his vehicle was confiscated. This was the last order of your Lordship. Well, while I'm submitting, don't interrupt, please. I didn't interrupt you. One submission has been made by my learned friend that I have given no objection to the bank at the time of auction. Lordship, there is no such no objection, because that was taken from me midway. I was regularly paying the EMIs. For some period, I was defaulted. Only a recall notice was issued to me. No proceedings under section SUVRA has been initiated. Suddenly, the recovery agents, by muscle power, they have recovered the vehicle. Subsequently, I preferred a writ petition. Honorable Court directed me to prefer appropriate application, Lordship. The SCGM sought the report from the investigating officer. All along, it was in my name. The documents, everything was in my name. He have released the vehicle to the registered owner. As per the jurisdictional magistrate, what else he would have done, Lordship? Now, my respectful submission before your Lordship is that if there is any manipulation tried to have been made by the petitioner before the registering authority,
Vehicle was directed to be returned.
Lordship.
It was in custody of the police authority.
Lordship, because Lordship, on the basis of the 156 clause 3 application, Lordship, it was recovered from an unknown place. It has been recovered and it was taken in the police custody. Therefore, I am being the lawful owner of the vehicle. I prayed before the London magistrate for returning of the vehicle, and the vehicle was returned to me, Lordship. This is the actual fact, Lordship. During the course of the investigation, they have not brought any document with the investigating agency or before this court as well. Now, Lordship, my respectful submission before Lordship is that the vehicle has been snatched away from me. It has, the due process of law has not been initiated according to the
Recorded in the earlier.
Lordship. Now, Lordship, what he is submitting before your Lordship is that candidly that I have given a no objection. He took time on the earlier two occasions to produce some documents. Today we can see, though I have not been served with the supplementary affidavit which he has filed today, but I thought that he will file something from my consent, which my client have suppressed from me. But that is not the fact, Lordship. Nothing has been brought on record.
Not served copy of the supplementary affidavit to the private respondent.
I have served upon the bank, upon the state. I'm serving here and now, madam. But only one thing.
And where is the document of consent?
Document of consent.
Submission on the earlier occasion.
Well, document of consent mildly will come when it comes to the affidavit which has been passed by the bank.
Respondent number 3, she's appearing. Yes.
Madam, page 23.
Of the bank's affidavit.
Of the bank's affidavit. Hereby, it has been stated that we hereby declare the agreement of purchase lease hypothecation entered between us has been terminated. We therefore request that the note endorsed in the certificate of registration being vehicles number this and this in respect of the same agreement between us is cancelled. Duly signed by Joy Shao. Once the agreement stands cancelled, the bank becomes the owner. And sales certificate has also been issued to that effect.
Page 90.
The sales certificate will comes to page 19.
How has the agreement been terminated without completion of the installments?
Yes. Sure. Without completion of, they have failed to pay the EMIs. We have given them a notice. It was also been before the paper. When it kindly comes to page 18. A paper publication was given by Canara Bank. Auction of the vehicle. The name was Joy Shao.
My lord,
yes.
May I be permitted to say something? Yes. My lord, after the first recall notice, several notices were given to them already. 15 days time was also given to them so that they may come forward, pay back the loan and do whatever. There is a sign of the signature of Joy Shaw in the seizure list also. My lord, these are the additional documents I've obtained apart from this affidavit, my lord. So the entire process was followed on behalf of the bank. Now, what happened, how the bus went back to Joy Shaw, that is something the bank do not know. Because we have already issued a sale certificate and it's deemed that once the sale certificate is issued, the sale is complete. They were given 15 days time also.
Joy Shaw's signature.
My lord, in the seizure, this document, the last
repossessed vehicle inventory list.
And moreover, he has signed this also. There's a signature at page 23 in my affidavit that the agreement has been terminated and he has put his signature.
In these documents, where is Joy Shaw's signature?
In the seizure list. These are the notices, my lord, and the last, there's a seizure inventory, seizure list. There's a signature in the beginning. At the top, my lord. This is something I just got.
The borrower's name is written. Where is the signature?
That is his sign. That is my bank's
What do
instruction.
you say it is his sign?
My lord, what happens?
It has been filled up in the same handwriting, the entire document.
My lord, it is I gather it is the notice that has been sent to Joy Shaw to settle the loan account because he was declared NPA on 18th of December 2020.
I think this is a very rare matter where affidavits need to be called for.
Well, let them. What I gather is, let them file an affidavit to that effect. That will serve my purpose.
Lordship.
Very well,
Annexing all relevant, because you are also coming up with documents. So let me call for affidavits.
Lordship.
Because an earlier order of this court, a criminal court order, so.
Well, one thing that is disturbing me a lot, apart from whatever.
And now this court passes a third order, they'll all be conflicting. I mean, these orders will all be in conflict.
Absolutely. Because once I becomes the owner, I can resell it to anybody else. But if there is a procedural latches and I'm aware of my procedural latches and I'm intentionally selling it to somebody else, then severe 340 lies against whoever it
They
is.
only say procedural latches, nothing more. Please come to page 15.
Lordship, SUVRA has not been taken.
Why surface would come?
No procedure has been maintained.
Notices was.
It is not a procedure that I will go and I will snatch the vehicle.
No,
This is not the procedure which has been adhered here, Lordship.
If the vehicle has been taken up forcefully, then the registered owner or the owner who has deemed to be the owner has to file the complaint. A person who is not the owner and who has signed it.
He's still the registered owner.
But that is on
The
the part of
latches on the
RTO who have
They have not rectified the name. That is the difficulty, which they have admitted subsequently. That all leads to the entire issue. Confusion.
Where have they rectified that subsequently?
They haven't. No?
I still then haven't.
There is no rectification. On this
There is no scope of rectification, Lordship. Because I am the owner. The vehicle,
the entire dues.
Lordship, till the date my vehicle was taken away from me, I cleared the entire due, Lordship.
No, let it be an evidence.
I have cleared it entirely.
Let it be an evidence.
Please take these documents back. You can come back by way of an affidavit. Our learned counsels for the parties. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, this court is of the view that the matter needs to be heard on affidavits. Paragraph, affidavit in opposition be filed within 2 weeks after the vacation.
Lordship.
It's after the ensuing vacation. Stop affidavit in reply, comma, if any comma be filed within a week thereafter. Reply. A week thereafter. Paragraph, let the matter go out of list for the time being, liberty to mention.
Lordship.
Next.
547.
But I appear for the petitioner, my lord.
I am for the respondent.
My lord. In these writ petition, yes, my lord. In these writ petition, my lord, I was, my lord, carrying iron ore from my lord Daitri to my lord Kharagpur. My lord, as per the master circular, my lord, the weighment has to be done where, my lord, the loading is being taken place. That is at the siding. The weighing machine was not proper according to the railway at that point of time. Therefore, my lord, there is a provision for associate alternate weigh bridge. That was, my lord, situated, which is 246 kilometers away from, my lord, the actual place of loading and nearer to, my lord, Kharagpur, where is the actual place of unloading. My lord, I'll take your lordship to the documents before I submit that, my lord, started loading from the month of 1st of November and it continued up to, my lord, the 18th of November. On all these occasions I have loaded, my consignment was found to be, my lord, overloaded.
Now, my lord knows, this is iron ore is taking from the mines. This is from Odisha, my lord. Under the Odisha mining and regulation, my lord, I cannot take beyond which is, my lord, permissible. My lord, there are several mechanisms and the documents are being issued by the government authority, and there are checking methods before which my trucks can take out, my lord, the iron ore. And this iron, my learned friend will not, my lord, object. These iron ore are being loaded in a dump and load method, which is, my lord, the moment I dump it, it has to be loaded, because otherwise cannot be allowed to, my lord, remain in, my lord, the open air. I made, my lord, the several requests to the railways that your function, the weighment machine is not functioning. They did not bother to, my lord, listen to me initially. I, my lord, made a request for reweighment that was not even considered. Now, my lord, I have given 2 or 3 letters. Thereafter, my lord, they themselves conducted a checking and found, my lord, the weigh machine which I was referring that is not in proper, my lord, working properly, that is out of order. On these premises, my lord, I filed a writ petition, my lord, and my lord, your lordships initially directed, my lord, the metrology department and, my lord, the railways to file a report, my lord. Now, my lord, in the report, my lord, the railway says that this was certified from, my lord, 8th of April to May 2023. So therefore, it cannot be said that it was not functioning. Though, my lord, I have their own documents to show that they say that it is out of order. Now, my lord, the legal metrology, my lord, the only difficulty is that your lordships remember, my lord, the issue was whether the machine, my lord, can be only defective from the date when the railway says. The railway legal metrology was direct to, my lord, indicate that whether, my lord, it could have been possible that it is not functioning prior to those dates. My lord, in the report, my lord, I don't find, my lord, there is any explanation to that effect, my lord, the legal metrology department. And that would have been a vital issue, my lord, in the proceedings since there.
The relevant period, it should be shown that it was not functioning.
Yes, my lord, because as per, my lord, railway, that was not even, my lord, I'll show, my lord, 2 documents. My lord will first kindly take, my lord, the railways document which says, my lord, it was not functioning, 185 of the writ petition. That it's a railways document, my lord. BPEIMWB is suspended period from 1830 hours on the date of 21/11/2022. On 20/11/2022, during the inspection, 185. During the inspection, the reading of the weighment found out of range. So BPEWEIWMB is suspended till further rectification. My lord, having this document on record, Railway, my lord, filed a report which says, my lord, page 2
of the report.
It stated that in motion wave bridge is Benapur is certified and stamping by legal metrology officer, inspector of legal metrology. My lord has got legal metrology, West unit, southern such.
Please.
Yeah.
Seven is legal metrology.
Yes, my lord, Segil means legal metrology, the rest.
Service. Two reports.
There are, my lord, one report by, my lord, the railway, one report by, my lord, the legal metrology, my lord. It is, my lord, the legal metrology's report is, my lord, by 2 to 5, my lord,
Yes,
affirmed on 28th July.
Yes, I found. Yes.
Yes, my lord. Page 2, my lord, paragraph 2. Paragraph 2, Roman 2, my lord. They say it is stated that hearing in motion wave bridge at Benapur is certified and stamping by legal metrology officer, inspector of legal metrology, Kharagpur West Unit 134, Paschim Mednipur, wherein the validity period was since 18/5/2022 to 17/5/2023. The copy of the certificate is annexed herewith. Hence, in motion wave bridge, Benapur was out of order on the said period is not correct. So, refund of unit charges does not arise. My lord, this statement is being made on, my lord, report. Well, my lord, I have annexed, my lord, the document as 185, which is their own document. They say, my lord, it went out of order on 20th. During the inspection on 20th, it was found and went out of order.
This says 20th May.
My lord, it is from 18 May 2022 to 17/5/2023, the period. And my lord will see,
This says 20, the inspection was on 20th November
November.
2022.
In between this period, my lord, seal it is in report says the validity is from 18th May 2022 and valid till 17th May 2023. And this inspection, in between inspection fallen within this period. 21st of November. May to May.
Yes, but for a day.
No, they say on 20th November 2022, it was found to be, inspection carried out, found to be,
out of order.
Out of order, Now, the legal metrology has filed also a report. Legal metrology, says on 28th of November, railway has intimated them that it has been went out of order. My lord will see, page 9, I stand corrected, 26th of November, page 9, the legal metrology says, sorry, my page, paragraph 9, page 4. By a letter dated such and such, stamping dated such and such, Senior Divisional Mechanical Engineering Southeastern Railway, Kharagpur informed the answering respondent that the said way bridge was breakdown since 26 November. So, railway has 26 November, whereas the railway documents say it is on 21st of November. The Senior Divisional Mechanical Engineer Southeastern Railway requested the answering deponent to allow to open the legal metrology seal of the way bridge at Benapur Railway Station so that it can be ratified and upon rectification to fix the upon stamping and verification in order to maintain authenticity of the same. So, they informed them on 26th. 21st happens. My case is that it was not working prior to even that date. Why I say this, as I indicated, that entirety has to be done, from the government document.
But these documents don't reveal that from 18th May it was not working, is it?
My case is of November, 8th of November, 18th of November. I have given my lord a chart in the writ petition on the page 5. The
They
date.
say that 20th November it was found, it was not working.
Not working. Why my lord will kindly now take page 5 of my writ petition. I have given a chart.
Page 5?
Page 5 of the writ petition. My lord, my loading date starts from 8th of November 2022 and I continued loading till 19th of November 2022. And the inspection was carried out on 20th of November as appear and found to be over. They declared it on 21st of November. So, my case throughout the railways was that it was not working. Why I say, there could not have been any possibility, My lord has seen, the first. No, heading is,
This is 8th November to 19th November.
19th November.
Next day they go for a check.
Go for a checking. That is because I was continuing, making representation that kindly go and check. Now, my case is that when you have found it, that it is not overloading, it is not possible, a machine will go, out of order on the first day. It is a possibility, that it was out of order on the previous day. Railway had carried out the inspection only on 20th and they come up with the report. Now, what I am speaking, if the legal metrology department, come up the report to specify whether these machines, can go out of order even before that date when the inspection of carried out or not.
Should have been pointed out, actually.
That was, if your lordships kindly direct them.
Kindly see my report.
Yes.
On the basis of the letter written by the Railway Authority, my officer done there.
When did they go?
First, my lord.
30th November they went there at paragraph 11.
Paragraph
11.
On the basis of the letter written by the paragraph 9, my lord, on 20th November 2022.
Paragraph 9 of the writ petition?
Yes. No. My report.
Yes.
Paragraph 9, page 4.
Yes.
By letter being number stamp 28 November 2022, the Senior Divisional Mechanical Engineer Southeastern Railway Kharagpur informs the answering respondent that the said weighbridge was breakdown since 26 November 2022. The senior divisional mechanical engineer requested the answering respondent to allow to open the legal metrology seal of the weighbridge at Benepur rail station so that it can be rectified, and upon rectification to fix up the stamping and verification in order to maintain authenticity of the same. A copy of the annex here. Thereafter,
How did you find that it was from 26 November and not earlier?
unless they give a letter, I cannot, I will not allow.
You have held that it was not working since 26 November.
Yes.
From where do you get this? What's the basis?
No. On
Paragraph
26
nine.
November 20, paragraph 19, it is respondent letter. Respondent says, Lordship, the senior
Letter is 28th November.
from the
Milord, that is page 7, Milord.
breakdown since 26 November. That
From where did you get this?
Milord, page 7 of the report. Page 7 of the report. Railway informed them that breakdown from 27. Page 7 of the report.
Alexander. Yes. Page 7.
So, Milord, there is a contradictory to the stand taken by the railways. If the document says 21st,
They were called for, well, we cannot enter. On the basis of the letter, we went there.
This was weighed on 26th November.
But
page 185 says again otherwise. These are contradictory.
yes, that both the railways documents are standing contradictory.
Railway says they
185
went.
repetition. You say the 20th you went for inspection.
Yes.
And this your report
We, Malad, inspected on paragraph 11. On 30th November 2022.
Milord, page 185 is the railway document. Railway made an inspection found to be out of range.
That was on 20th November.
20th November, they suspended from 21st.
Yes.
Then they wrote a letter to legal metrology saying that it is out of range from 26.
On 28th.
The letter received by them on 28th.
Yes.
Then they opened it and they certified on 30th. So, Milord, what I am seeking, Milord, the legal metrology being, Milord, the specialized in this field, should come up whether, Milord, my case is that whether the machine was not, is it possibility
On
that
paragraph 11, Lordship, kindly see. On 30th November, the answering deponent inspected the said weighbridge and found it conforming to the standard mandated under the legal metrology general rules 2011. Upon being satisfied, the answering deponent stamped the said weighbridge and issued the verification certificate, a copy of it. This is the Malad, my stand.
So there you say 30th November.
30th November, we rectified. 28th letter received, 30th we rectified.
You rectified on 30th. And your chart, the chart in the repetition?
chart is from, Milord, 8th of November, page 5 of the repetition, 8th of November till, Milord, 9th.
8th of November.
Yes. And the railway carried out.
I have no knowledge about.
That is.
Unless railways inform me, otherwise I cannot go here.
Let us hear the railways.
And Milord, what I was seeking, Milord, being the specialized, Milord, they should come up whether it's possibility that the machine was not. That was, Milord, the idea of to file the report, Milord. That, Milord, if your Lordship direct them
unless,
to.
Unless the railway authority.
No.
But as far as 185 pages concerned, my lord, that is not, my lord. There are no seal, my lord. Only, my lord, just handwritten report, my lord.
Are you denying this document?
Then I have to take, my lord, instruction, my lord, whether it is, my lord, authentic or not, because there are, my lord, contradictory statement by the state authority.
Document along with the writ petition?
Yes, my lord.
You have received this document along with the.
That is true, but I am as per this, my lord, metrology report is concerned, my lord.
Have you challenged the veracity of this document anywhere?
Yes, my lord.
Have you challenged the genuineness of this document anywhere?
Now, not, my lord, as far as my instruction is concerned, my lord, that is not authentic as per my knowledge, because that is contradictory as per state report and our report also, my lord, our affidavit, my lord, in opposition, my lord. So, my lord, your lordship, kindly give some time that I can verify whether this report correct or that report correct, my lord. Otherwise, my lord, I cannot go into conclusion.
Process. Please take proper instructions on the next date.
Because otherwise, in the previous day, my lord, no argument as far as this 185 is concerned, my lord.
So
Today,
each day one topic comes up and you take instruction on that particular topic.
yes, but as per
This
APDB, my lord,
instruction.
that is okay, my lord, that as per state government report.
Okay, as on 30th November, not
Yes.
before that. And the period under dispute is 8th November to 19th November.
But legal metrology report, my lord, says quite.
30th November.
Yes, my lord.
The dispute is 8th to 19th.
But,
even if it is found to be correct on 30th November, how does it help you in the writ petition?
but you'll also come to my APDB, my lord. That is page.
To see documents on the basis of which it can be held that from the 8th to 19th, the weighbridge was functioning.
That is certificate, my lord. You'll also kindly come to my lord, certificate, my lord. That is annexed in my report, my lord, dated. Dated, my lord, 20th July, my lord. Last page, my lord. That is a certificate, my lord, made by the legal metrology department, my lord.
Yes.
That minimum that certificate, my lord. That is 13/8/2022, my lord. As per this certificate, my lord, this ABDB, my lord, you'll also kindly come to my lord, page 2, para 22. It is stated in motion, OAB at Benapur is certified and stamping by legal metrology officer, inspector of legal metrology, Kharagpur, West Unit number 134, Paschim Medinapur, where in the validity period was since to 18/5/2022 to 17/5/2023, my lord. That is their certificate, my lord. That is last page, my lord. That is page 7, my lord. That is certificate made by the, my lord, legal metrology department, state of West Bengal, my lord. Page 4, my lord.
Page 4.
Yes, R1, my lord. Only one annexure, my lord.
Of the railways report.
My report, my lord. My report, my lord. That is, my lord, on behalf of respondent number 2, my lord.
Yes, what does it say?
Hiroshi Kali, come to page 2, paragraph 2(2). That I have read, my lord. R1, my lord. The copy of the certificate. That is last page, my lord, page 4.
Yes.
That certificate reflects that, my lord, period, the validity period was 18/5/2022 to 17/5/2023. That is certificate, ma'am.
That the period, during the period under consideration, the weighbridge was working. The petitioner says it was not working.
Yes, ma'am. That I have made some instruction, ma'am,
To 19th.
on the specific point, my lord.
Because these are all after that.
But, my lord, the certificate was there. But despite that certificate, my lord, even if, my lord, for the argument's sake, takes 185 was as its claim, but it is an admitted position, it went out of range because they have wrote to the, my lord. So, my lord, he is relying upon to show that it was within range on the basis of legal metrology certificate. Then if that has to be taken care, my lord, within that period, that could not have been in the out of range. My lord, that argument cannot stand, my lord, because they say it was out of range.
On the last occasion, another matter, my lord, certificate, your lordship, came into conclusion that certificate is the last thing, my lord, as far as medical metrology is concerned.
Agreed, my lord,
The
provided
certificate
there is no
reflects that this is not out of order as per these documents, my lord.
Therefore, my lord,
But they are 185, as far as 180 page 185 is concerned, my lord.
Reflects that it is not out of order.
That is the handwritten, my lord, report, my lord, that I have to check
What
it.
does it reflect, sir? Please find, tell me.
That is handwritten statement, my lord.
From the date?
That is handwritten statement, my lord. That I have to check it up, my lord. That is handwritten annexure, my lord. I cannot rely it, my lord.
Comprehensive instructions. Every day one point is taken and you come back, you say I have to take instructions.
Sorry, my lord.
You cannot take instructions on each line on each day, isn't it? Please come back with a call, or shall I call for affidavits in this matter? Let all the documents come before the court.
Yes, my lord.
Ms. SUVRA?
Yes, my report cannot be solved all the problem.
the only thing, my lord,
Checking, 20th checking is not relevant to this matter.
Yes, my lord.
Because the date is 9th to 8th to 19th.
My difficulty is unless the railway calls for because I cannot
No,
enter into that.
the railway has to show that from 8th to 19th.
It is a railway fault. He has to do. It's already stated in the page 185.
Let affidavits be called.
Yes, my lord,
Every
product-
day, one instruction, this is not possible.
My lord, will kindly fix a date for hearing then, my lord, because it has been going on for long, my lord.
Mention immediately upon completion of affidavits, I'll fix a date over here. Why lengthen the list unnecessarily?
No, my lord, only one thing, my lord, I was thinking, my lord, if the metrology department, which was trying to, my lord, impress upon your lordship, that whether it is possibility or not, because they are the specialized agency, my lord. If they come up with the any finding, that would have helped, my lord, the adjudication process.
Permit.
What I'm
They have checked on a particular date.
Yes, my lord.
So how can they help the court with the finding that it was either working or not working prior to that or after that? It's limited, isn't it? The day they examine the machine, they'll say it's working or not working. Now, prior to that, what happened, or after that, what happened? They are not in a position to say.
That is my scope.
Let the railways come back and show that the machine was checked from time to time, and the documents which show that the machine was working.
Great.
Because that's your claim here.
Yes.
To hold the punitive charges, the railway has to substantiate. Mr. Chakraborty, the burden is on you. So please come with relevant documents.
Yes, ma'am. I will file, my lord, parawise opposition, ma'am. I'll file.
You don't need to file opposition.
No. Because I have already filed a
Yes, ma'am.
stating all.
A learned counsel for the railway authorities seeks to use an affidavit in opposition in this matter, annexing all relevant documents. Paragraph, affidavit in opposition be filed within 2 weeks after vacation. Within 2, please comply with this.
Yes, I will try my level best. Your worship, no, that government
thing
office.
is being repeated.
Yes, sorry, my lord. Extremely.
Within 2 weeks after the ensuing vacation. Affidavit in reply, comma, if any comma be filed within a week thereafter, reply. Paragraph, let the matter go out of list for the time being, liberty to mention.
Great.
Under the heading, my lord, hearing, my lord. It will listed
Mention upon completion.
After completion.
Yes.
Next.
Number 548. Why application? ওদিকে যাও তোমরা রেসপন্ডেন্ট ও তুমি তো অ্যাকচুয়ালি এখানে রেসপন্ডেন্ট
My lord, I kindly see the order of the Honorable Court dated 17th November 2023.
Let the petition
Our
start.
petition also, my lord, tagged in this petition.
Mr.
But this matter is not appearing in the list. But this matter is not appearing in the list.
This is not appearing in the list. Now, my lord, in my matter, your lordship kindly see the order dated 17th November 2023.
This is my report, whether pursuant to my lordship.
Now, your lordship kindly see, learned counsel for the state respondent seeks to submit a further report in the form of affidavit indicating that resolution in question was actually taken upon approval of the Transport Department as well as upon obtaining no objection from the Secretary Regional Transport Authority, South 24 Parganas. Now, my lord, the report says.
You have received a copy of this?
Yes, report says, 1 minute, no approval from the Transport Department has been taken. It's not required. Well, I do not know. Somebody has given instruction to Mr. Debray that approval is there. Not only instruction, it is also their categorical statement. In your lordship kindly come to this page 61, their resolution. Page 61 of the writ petition.
Yes.
Resolution. President, Secretary, RTA, etc. appeared before the RTA board meeting and they were duly heard. RTA discussed the matter and has decided to issue notice to Secretary RTA Kolkata within 7 days. 7 days to permit holder route number 39 for endorsement of existing route alignment. Next. No, prior to that, sorry. কোথায় গেল ওটা? Page
47A.
Page 47, I'm sorry, page 47A.
Yes.
Page 47A, 47A. This is the incorporation in the permit. They say extension of the alignment of the route number 39A2 up to Hojerat, subject to necessary approval from Transport Department as per decision of RTA Kolkata dated 9/2/2010. Now the RTA Kolkata in their affidavit says, in their report says, supplementary report says, no approval is required. I do not know. This is their resolution, 9/2/2010. Now they say it's not required. Your Lordship, can you see?
Subject to necessary approval from Transport Department.
Yes. Now your Lordship, can you see? Their latest report. Yes. Your Lordship, can you come to paragraph 8, I believe.
No, you have not filed any exception.
I will.
তাহলে exception এ তাহলে আবার তো
দাঁড়া ভাই, একটু গৌরচন্দ্রিকা না করলে হয়?
If you want to come back with exception, come.
Certainly, I have to.
Because my date is also.
I have to because two decisions are contradictory.
Yes.
Because no copy of
I have to satisfy before your lordship.
Which is not sir.
Which
Report.
official says that approval is there?
Let him appear, let him file an exception to this.
one copy is required to me because I make another.
You are appearing in this matter, isn't it?
Not in this matter. It is my read petition. He have been added as a party because another read petition is filed on his complaint.
Please serve a copy to Mr. Khan.
Naturally, that should be in the January, not this side of the vacation. It can't be possible.
This is an additional report.
This is additional.
Report submitted on behalf of the state respondents is taken on record. Paragraph learned counsel for the petitioners seeks to use an exception to the report. Paragraph let the matter appear under the same heading on 24th January. 24th January.
The only thing, there are today we are on 11th of December. 24th of January is long time. If they take any steps for removing me, then I shall be in the grade. So my read petition will be.
Very well. Come back on 15th January.
Very well. Your Lordship, give little protection till 16th of January. No. It has not been implemented. We are still operating.
2010 is going on.
No. We are.
And
What Mr. Debra is saying.
Mr. Chatterjee's client also operating their vehicle in the respective.
No. Your Lordship, your Lordship kindly come to page 25.
Fair table also.
Page 25, your Lordship kindly.
They are illegally operating their vehicle.
No. This is if it is illegal, then I am operating illegal. Your Lordship kindly go page 25.
Yes.
This is the route given by the RTA Kolkata.
Yes.
This is the route. I am operating in this route. Now they say illegally operating. Huh?
On the same route, my lord, party has been issued Hojerat to Hapa station.
Maybe I am not concerned with it. They are not the read petitioner. No. Maybe. But your Lordship, this is my permit. I am concerned with this. Mr. Debra says I am illegally operating. Now, their resolution says it has to be approved by the Transport Department. Now they are saying no.
There are 4 routes.
Maybe.
What maybe?
Come back with your exception of 15. Please serve an advance copy. I don't think protection is necessary till then. No further action till 15.
Maybe.
No.
If Mr. Debra says I am okay.
I am not passing any order, Mr. Debra.
Very well. If Mr. Debra says
yes,
I have not, it is more than court. He is more than court.
What is the other writ petition connected to this?
Yes, my connection on my route.
They want to implement this resolution.
What is the number of your writ petition?
The number has been given the order.
It is appearing in the list.
No.
Can you see the order?
লিস্টে নেই না লিস্টে নেই সেটা শুধু তো ব্যাকই করবে
নাম্বারটা দাও
I think it's together. It's appearing together.
Yes.
কি order হয়ে আছে?
No, your Lordship has said this read petition.
This is analogous. Yes.
Analogous.
Problem bit আছে। লিস্টে আসতে হবে এভাবে রিড করে রিড করে দিন নেক্সট
আজকে হচ্ছে 11/12।
Item 549. My lord, in this matter, my lord, I beg to appear for the petition, my lord.
আমরা 15th বলেছিলাম 15th January yes
My lord, my allegation.
Before
is
my
that, my lord,
learned friend opened the matter, I am for the private respondent. He has challenged my permit. In the same sense, several lead petitions were there. Ultimately, Honorable Justice Motion Bhattacharyya passed an order. Against that, appeal has been preferred. That appeal will likely be taken up before the Honorable Division Bench. To that effect, Mr. Shaktipada Jana moved a similar lead petition that has been he paid for. That has been go out of the list from the lordship.
My lord, that is regarding counter signature, and this is regarding, my lord, the illegality in the permit, my lord. The route alignment has been changed at the time of renewal of the permit, my lord. The entire alignment has been changed, my lord. Page 28, my lord, kindly comes to my lord. Page 28, my lord, will kindly see, my lord, the route alignment, my
My
lord.
honest friend is trying to reissue the revisit the issue.
No, my lord, that is regarding counter signature. This is very clear, my lord. The order is here, my lord.
Matter was heard by the learned single bench, my lord, at least 20 officers.
same issue
Same issue.
No, my lord, kindly have a look at the order, my lord. Very first line, my lord.
Lastly, my
The-
lord,
Yes, this is regarding counter signature. Very first line, my lord.
Counter signature comes in a permit within a route.
This is regarding the route alignment.
Alignment is the same.
no the counter
No.
signature is not
Different issue, my lord.
alignment isn't
It's
it
a different
They are two
issue.
Manaswi, pardon me for 2 minutes to clear the entire issue. Permit has been in the year 2006 by the Jharkhand authority. That has been placed before the West Bengal authority for counter signature. That has been denied by notification. That notification is challenged before
My
this
lord,
honorable
kindly
court.
comes to page 28, my lord. Let me open the case first.
give me a minute please
আমি প্রথম অর্ডারটা দিয়েছি যেটা মৌসুমী ভট্টাচার্যের অর্ডার অনারেবল জাস্টিস ভেরি ফার্স্ট অর্ডার very first line is regarding counter signature.
incorporate
this is counter signature of permit how is it connected to the
No, this has been finally been disposed of. You will also kindly see the order dated 1st August 2023.
order dated 27 January
Now, this is regarding final disposal of the matter 1st August 2023.
It is pending last 2006. Since 2006. Now at the behest of the Justice Division Bench of your court, well, Division Bench intervene in this matter and directed both the authorities to sit together, either virtually or anything, and tomorrow it will be fixed. Tomorrow, okay, fixed. Tomorrow it will fix for you. Report submitted by the state.
From the state of control, there is a 2 alignments.
it's also alignment of routes yes
My lord, kindly take up the matter on Wednesday, my lord. Wednesday, my lord.
out of list come back after the division bench decides it is submitted on behalf of the respondents that a similar issue as in the present writ petition is pending consideration before an honorable division bench of this court. Paragraph in view of the above, let the matter go out of list.
My lord, liberty to mention.
Liberty to mention.
Grateful, my lord.
Number 550.
Lordship, I am appearing for the petitioner. On last occasion, Lordship, the respondent has directed to file a report, but till date nothing has been.
Appearing for the respondents. Mr. Gabriel is okay. Did you file your report, Mr. Debra?
No, my lord. Beast.
So 1 minute.
North 24 volts, South 24 volts.
Let him come. Learned counsel for the respondents seeks extension of time to use the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 17th January.
Lordship, one more thing I want to submit that on last occasion, your Lordship has directed to add Thakurpukur traffic guard as a party, but I didn't added on that day. Lordship, kindly give me
Yes, please. Grateful, Lordship. Constantly to correct code. Next.
Number 551.
I think you are for the response.
Yes, petitioner.
551.
Petitioner.
Alex.
Where is he?
We are not interested to proceed. Number of days we are not interested.
None appears for the petitioner. No accommodation is sought. Dismiss for default. Where are you?
I have a different matter in quorum of 14. I was checking now.
Yes, you are ready?
Yes, my lord.
Yes.
My lord, this is regarding, my lord, the flying of a bus, my lord, is not covering the entire route, my lord. The entire route alignment, my lord, I have lodged the complaint before the police, my lord. They have not taken any action, my lord. The last action, my lord.
So this is police in action. This court doesn't have determination.
The motor vehicle matter, my lord, is not covering the violation of the condition of permit.
Police in action.
Section 66, my lord.
With regard to any matter. This court doesn't have
Section 66 violation is there, my lord. Public safety is, it is not containing the covering the entire route, my lord.
Your prayer is for police in action, sir. I am releasing the matter. Group 9, isn't it?
Yes, I filed a complaint before the secretary also. I filed a complaint before the secretary also, RTA. Hello, Annex P2, kindly see, my lord. The RTA. Both of them are sitting tight.
You have combined all of them. RTA, police, everything.
Yes, ma'am. My lord, everybody, my lord, if a bus is flying, my lord, violating the condition of permit, lord, the RTA has got some duty, my lord.
Can police in action be dealt with by this court? Please tell me, sir.
That is there, my lord. But my lord, I
If
also,
that is there, then
I have
how
also
can I?
invoked the secretary of the RTA, my lord. I have informed him, my lord. Not that I have not informed him, my lord. He has received the letter, my lord. He is ignoring it, my lord. That is all, my lord, I am saying. Now it is up to your lordship, my lord. If your lordship releases the matter, I have nothing to say.
Let me release it. Let the appropriate court deal with it. The petitioner primarily alleges police inaction. Primarily alleges police inaction. Paragraph, the matter be released due to lack of determination.
Released.
Next.
550, 552. Following this matter, I am appearing on behalf of the private respondent number 4.
Petitioner.
My lord, I am on behalf of the petitioner. My lord, I am led by Mr. Satik Bhattacharya.
Simpliciter, my lord, the objection, my lord, against the private respondents for cancellation of permit as well as for taking an appropriate measure, my lord, is to be considered, my lord, by the STA. That is the annexure P2, P4, page 36.
Page 36.
36.
Well, I am appearing on behalf of the private respondent allegation, my lord, that
Let it be decided by the authority.
Having seating capacity for 50, 57, and tax was paid for. It is not the correct.
Let it be decided by the
Initially, my lord,
authority.
57. They have to made an application for extension for seating for extension for seating capacity. 57. After 57, I have paid the tax fee of 57. Then I record. I have paid. I have no objection at all because this delegation is not the correct for this reason. This is my duty to.
I'm not going into merits.
Yes.
The representation.
Yes. And take a decision after
hearing both parties.
Yes, yes,
All
all concerned. Yes.
All concerned.
The petitioner seeks consideration of a representation submitted by him before the secretary.
Yes, my lord.
Secretary.
Secretary.
Respond number
Respond number 2.
Before the second respondent.
Second respondent.
Second respondent is the chairman.
Yes, madam.
No, chairman no. Secretary STA. Secretary has not been party.
Has been not
The leave
made a party.
Leave may be granted.
Add him.
Leave may be granted.
Prathame, on prayer of the petitioner, liberty is granted to implead the Secretary, State Transport Authority, West Bengal, as respondent number 5 in the writ petition. Paragraph, the cost title of the writ petition be amended accordingly. Therefore, the petitioner seeks
Secretary power nahi ko. Eta
a
STD
direction
power.
upon the
Amolda.
respondent
Amolda.
to
STD power.
consider
Secretary
the
power to no.
representation
Delhi
submitted by
support
him
the section 86.
before the authority on 25th July 2023 for cancellation of permit of the private respondent.
My submission may be recorded because that allegation I deny this.
What is your, I'm not on merits at all.
Yeah.
The allegations has been denied by
Paragraph,
Amolda. Secretary
and
program
the
chairman
representation is yet to be considered.
STA board.
Paragraph, upon consideration of the submission made under the parties, comma, the writ petition is disposed of, directing the fifth respondent to consider the representation submitted by the petitioner dated such
Secretary Kutor and STA
within 4 weeks. Within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner and the private respondents. Comma, in accordance with
After hearing both parties.
Yes.
4 weeks from the date of communication.
Only one thing, my
Resolution
lord.
will take it.
4 weeks from the date of communication of this order. Yes.
Another thing is that in course of taking such a decision, if it appears the secretary that the matter be referred to the HTA board because the cancellation of permit is its prayer, then he can refer the matter to the board. Kindly. Because
it's not necessarily stated. I'm not going to
Secretary has no
quasi-judicial power.
Law says board, he'll send it to the board.
My
That is being done also in various cases.
lord.
Paragraph, the decision taken by the authority shall be communicated to the parties within a week thereof.
My lord.
Disposed of which.
Deeply.
Next,
Oblige, my lord.
hearing matters. A 330 matter is there.
Yes.
Item number
Matter,
600.
item number 600. My lord, item number.
এর আগে আছে বনি
এর আগে
330 আছে
600 is a 330 matter. I'll deal with that.
and
first.
thereafter from 579 330
Yes.
My lord, from group 1 matter, first matter, before that 2 matter fixed at 330.
Where is it recorded?
My lord, my matter is WP 12247 W of 2007.
Or it's 330, Shantanu?
2017.
579 is 330 hearing matters and
That is the usual hearing matters. One matter is specially fixed at 330.
it is specially
Thereafter, my lord, you
Thereafter, take up the matters. 600 to the
I'm on the other side
18294. Yes.
Well, this was the matter where allotment of land, my lord, had been cancelled by the authority on the basis that we could not start construction within the time specified in the lease deed, my lord. My lord, my learned senior, my lord, he had also placed some judgments, and the arguments were based on the fact that we have no legal right, therefore the writ petition is not maintainable. No legal right. Some judgments were cited on that, and also this is a commercial contract. Therefore, the writ petition is also not maintainable. But the judgments which have been cited, I will distinguish those, and my senior is on his way. He will come and conclude, my lord. I'll just distinguish the judgments, my lord, if your lordship takes, my lord.
Also made its submission.
My lord?
The KMDA has also.
My lord, KMDA, my lord, these were the submissions of KMDA. My lord, our submissions,
Reply.
I'm on reply, my lord. My lord, KMDA, my learned senior Mr. Dakto, he had argued that my writ petition is not maintainable on two counts. Number one, that I have no legal right. Having no subsisting legal right, I cannot maintain a petition.
It's a private contract.
And it's a private contract. Commercial contract, it is not maintainable. On that, he had also cited some judgments. But if your lordship takes, I will distinguish those judgments first, my lord, if your lordship takes. My lord, he had cited 2012 5 SCC, 2012 6 SCC, and 2014 14 SCC on the point that there is no right created in favor of the writ petition, and therefore the writ is not maintainable. Well, should we just sort out the judgment? There are quite a few, I think. I can sort it out and just hand it over.
Thank you.
I will just sort it out in order. Tanini? Awardটা দেওয়া হয়েছিল awardটা দেওয়া হয়েছিল award well লিখিয়েছিল Well, these were cited by us, and these are my learned seniors on KMDA. Well, I've put it in order the way, my lord, it is to be distinguished, my lord. Well, the ones which is on your lordship's left, my lord, those are.
I'll just.
Yes, ma'am.
Yes.
Huh? I think I handed over my note to your lordship.
Yes.
I think I handed over my notes to your lordship by mistake. Should I just check once, my lord?
No,
No, I will suggest. Oh, last day. Sorry, my lord. Arekta patra. Arekta. Sorry, my lord. I just my notes.
Yes.
My lord, if your lordship takes 2000, huh? আমার হাতে নোট লেখা হাতে লেখা judgment গুলো distinguish করবো যায় my lord, if your lordship takes the first judgment Maria Margarida, that is 2012 5 SCC 370.
Yes.
My learned senior had relied on para 62, 97.1 and 97.4. My lord, will kindly take those paragraphs first. Paragraph 62.
Yes.
Possession is an incidence of ownership and can be transferred by the owner of an immovable property to another such as in a mortgage or a lease. A licensee holds possession on behalf of the owner. And thereafter, my lord, para 97.1. Oh, 97.1 কোথায় আছে? Sorry, para 62 and then 68. কি বলছো? ভুল লিখেছি।
62, 63, 64.
Yes, my lord. Yeah, 62, 63. And my lord, then my lord, if your lordship comes, my lord, right at the end, the conclusion, para 97.
Yes.
Principles of law which emerge. My lord, if your lordship takes 97.1 and 4. No one acquires title to the property if he or she was allowed to stay in the premises gratuitously. Even by long possession of years or decades, such person would not acquire any right or interest in the said property. Then, my lord, I'll read out all of them. Caretaker, watchman, servant can never acquire interest in the property irrespective of his long possession. Caretaker or servant has to give possession forthwith on demand. The courts are not justified in protecting the possession of a caretaker, servant, or any person who was allowed to live in the premises for some time, either as a friend, relative, caretaker, or as a servant. The protection of the court can only be granted or extended to a person who has a valid, subsisting rent agreement, lease agreement, license agreement in his favor. The caretaker or agent holds property of the principal only on behalf of the principal. He acquires no right or interest whatsoever for himself in such property, irrespective of his long stay or possession. This is what the judgment says. My lord, if your lordship sees the facts of this case, they were altogether different. Number one, this was not a writ petition at all. Here, there was a dispute between, if your lordship takes paragraph 3 onwards, 3 to 11. I will show it, my lord. But before that, if your lordship I'll narrate the facts. There was a dispute between a brother and sister regarding a property in Goa. Undisputedly, the property belonged to the sister. Sister had given the brother just the right to use the property as a caretaker to ensure that nothing wrong happens in the property, because the brother used to live in a house which was next to this property. Subsequently, the brother hands over possession of the property, hands over lock and key, everything to the sister. The sister is in possession of the property. At that point of time, the brother files a suit for injunction under section 6 of the specific and a suit under section 6 of the Specific Relief Act, saying that possession was wrongly taken. On that count, the sister takes up a legal point that the brother had no legal right over the property whatsoever. He could not maintain a suit under section 6. That is why Supreme Court came to these findings. But at para 2 to 11, your lordship will find that the facts have been set out. 2 to 11. If your lordship takes paragraph 3, both appellant and the respondent hail from state of Goa and belong to leading and well-known families in Goa. The father of the appellant and the respondent, so-and-so sequera, by an affidavit, Malat, it need not go into all details. Malat, then if your lordship takes straight, Malat, paragraph 9, the appellant submitted that she got married on such and such date to an officer of Indian Navy who was posted from time to time in different places in India. She also submitted that the respondent, her brother, requested her that as his office is just adjacent to the suit property, therefore, it would be convenient for him to run his office and to keep an eye on the suit property for the appellant. Therefore, the suit property was given to the respondent only as a caretaker. Well, then if your lordship just turns over to paragraph 13, the appellant submitted that she has a valid title ownership and was in possession of the suit property, and she could not be dispossessed by the court in a suit for injunction. The appellant submitted that under section 6 of the Specific Relief Act, the appellant could not have been legally compelled to hand over possession to the respondent. It may be pertinent to mention that the respondent filed a suit for injunction before the trial court. The trial court granted injunction in favor of the respondent, and the same was upheld by the High Court in the impugned judgment in civil revision by the application. Well, then para 15 and 16 is the finding. The appellant urged that the respondent's suit for injunction was not maintainable, as he could not claim to be in lawful and legal possession of the premises at all. The appellant argued that the courts below have missed the main issue, as the respondent was merely in custody of the house on the basis of the appellant. According to her, a caretaker can never sue a valid title holder of the property. The appellant further urged that the caretaker's possession can never be a possession of an individual's right, and no suit for injunction under Section 6 of the Specific Relief Act was maintainable. So on this basis, that he was merely a caretaker, Supreme Court came to these findings that the suit was not maintainable. And therefore, my lord, para 97, those principles of law enunciated with regard to a caretaker. This is, my lord, the first judgment. Our facts are altogether different. I have validly entered into the property on the basis of an agreement. Agreement has been, according to us, wrongly terminated. We are saying that the cancellation of the allotment is wrongful. On that basis, we have come to court. It cannot be said that we do not have any legal right. So these facts, my lord, are not opposite to the facts of our case. My lord, the second case, 2012 6 SCC 430. My lord, once again, my lord, what has been relied upon is, my lord, para 43. On the similar principles, my lord, watchman, if your lordship takes paragraph 43.7, watchman, caretaker, agent holds the property of a principal only on behalf of the principal. He acquires no right or interest whatsoever in the property, irrespective of his long stay or possession. 43.8, the protection of court can be granted or extended to a person who has a valid subsisting rent agreement, lease agreement, license agreement in his favor. This was what was placed. My lord, your lordship will again take the facts once, my lord. My lord, at paragraph 1 to paragraph 6. My lord, before I read out the facts, here, my lord, there was a dharamshala. The dharamshala was owned by a society, a registered society. Society had appointed a watchman. The watchman died. Watchman's son was in possession of the property. Watchman's son claimed to be in possession and he was not giving up possession. Two suits were filed, one suit by the watchman, one suit by the society. Both courts, the lower courts in both the suits, passed orders in favor of the watchman. From that, the matter went to Supreme Court. Your lordship just reads, my lord. Paragraph 2. The property in question belonged to one Madhu Naikar, who dedicated the suit land for construction of a dharamshala. In the southern part of India, it is called Choltri. A dharamshala is commonly known as a place for boarding facilities as provided either free of cost or at a nominal cost. In the instant case, a dharamshala was to be constructed for the benefit of Arya Kshatriya community. The appellant's father, Appadurai Pillai, was engaged as a watchman on a monthly salary by the respondent society to look after the dharamshala, and in that capacity lived in the premises with his family, including the appellant. According to the appellant, in the year 1994, the respondent society, claiming to be the owner of the suit property, tried to dispossess the appellant by force, necessitating the appellant to file suit in OS 1143 of 1994 to be filed before the second additional district munsif, Tiruvannamalai, praying for issuance of permanent injunction against the respondent society. The suit was, however, dismissed. Against that, the appellant preferred an appeal as AS 94 of 2001. On the appeal, the additional district judge allowed the appeal and consequently the suit was decreed. So the watchman won the decree. Second, the respondent society preferred a second appeal before the High Court at Madras against the said judgment of additional district judge. Now, the second suit is paragraph 5. The society, respondent society, during the pendency of the second appeal, filed OS 239 of 2003 before the additional subordinate judge, praying for declaration of title and recovery of possession, and the suit property comprised TS so-and-so. The said suit was decreed as prayed for. Against that, the appellant preferred an appeal on the additional district judge, Tiruvan, and the decision of the trial court was reversed in the appeal, resulting in dismissal of the suit filed by the respondent society. Aggrieved by the appeal being allowed, the suit being dismissed, the respondent preferred a second appeal before the High Court Madras. 6. The learned judge, Madras High Court, heard both the aforesaid appeals together and by a common judgment set aside the well-considered judgments of the first appellate court. Aggrieved by this common impugned judgment, the appellant has preferred these appeals by special leave. So watchman came in appeal before Supreme Court. And on that basis, Supreme Court gave these findings and dismissed the SLP. So again, my lord, the entry was on the basis of a watchman or a caretaker. Not, my lord, in our case, where I've entered by way of an agreement. And this was altogether different facts. My lord, then, my lord, 2014, volume 14, SCC 716.
Yes.
In this case, my lord, it's a short judgment. I'll tell your lordship the facts, what transpired. My lord, the a government organization, they, like our case, my lord, gave an allotment of land to a company. After that, my lord, in terms of that allotment, the company was to make payment of the premium within a particular period of time. That payment was not made. The premium was not paid on time. Some part was made. The agreement also contained a clause that if the payment is not made on time, the money will be forfeited and there will be restitution of possession. While this was pending, the company went into liquidation. An official liquidator was appointed. Official liquidator took steps in the company court, in a winding up court, to have the property sold on the basis of the whatever rights was there. While in the winding up court, a disclaimer application was filed by the corporation saying that the company has no legal right over the property. Therefore, the OL cannot claim any right over the property. We should get the property back. In the High Court, the company won, as in the official liquidator won, the corporation lost. From that, my lord, in the SLP, if your lordship takes paragraph 12, right at the end, my lord, these are the facts, narrated facts. In the aforesaid circumstances, we are of the view the High Court was in error while coming to the conclusion that the appellant had no right in the plot in question, and therefore the impugned judgment as well as the order passed in the company application are quashed and set aside. It is held that the plot in question does not belong to the company in liquidation. Official liquidator has no right to deal with the said plot of land or dispose of the said plot, and it would be open to the appellant corporation to deal with or allot the plot of land as per its own policy. Altogether different facts which were here, my lord. Here, my lord, we have made payment of the entire premium. We have also got sanction plan. Subsequent to that, we could not construct the property on time. And here, this is also not a writ petition. Legal right of the person who was in the property, that was not in question here at all. The other two cases, the legal right to initiate a proceeding was in question. Here, that was not in question at all. So I do not know how this judgment helps, my lord. The forfeiture of the amount by the corporation, that was also allowed. Now, my lord, the next judgment, my learned senior has relied on, is 2002 Volume 4 SCC 638.
2002?
2002 Volume 4 SCC 638. My learned senior, I think, has relied on paragraph 17. As in my Mr. Dotto has relied on paragraph 7. Well, 2002, I think I'd kept it, my lord, there. 2002 Volume 4 SCC. I kept it in order if I missed it.
No, the next is 2008, volume 12.
Oh, that's the next. I can show that also, my lord. Those were on, my lord, 2008 Volume 12 and 2023 4, the St. Mary's Education, my lord. Those were on contractual right. Writ court will not get into disputes regarding contractual right. My lord, your lordship.
8 volume 12.
Yes, my lord. 2008 Volume 12 and 2023, there is a SCC online.
22.
22 SC. It's St. Mary Education Society.
St. Mary's
Well, that is now reported as 2023 Volume 4 SCC 498.
2023 volume 4.
4 SCC 498. Well, these two judgments were on the contractual rate. Well, there's one more if your lordship. It should be 2002 4 SCC 638. Well, I have another copy with me that my learned senior had shown.
I do not find it here.
Well, I saw it when I was going through.
2004 volume 2.
No, well, that has been shown by.
That is you've shown that. SCC 130.
Yes, ma'am. This should be 2002 Volume 4 SCC 638. I think I just saw it, my lord. It should be there.
No, I do not find it here. Has it gone back to you again?
Not no. Well, there's one copy. I have an extra copy. My lord, my learned senior had relied on paragraph 17 of this judgment.
1717?
17. He had relied on para 17.
Yes.
Again, on the point that there is, if one who does not have a legal right cannot initiate any proceeding, legal right on a property. On that same point, my lord, here again the facts were altogether different. Under the Estate Abolition Act 1948, my lord, lot of land had been, my lord, the estate, the Nawabs and my lord, the Raja of Venkatagiri, their properties were all taken away. So right of compensation was there, and the Abolition Act itself provided that there will be an interim compensation which is payable till such time the final compensation is adjudicated. There was an Ordinance Act which came in 1961, by which this interim compensation power was which was to be given, that was taken away. So it became only a final compensation. So the Raja of Venkatagiri challenged the vires of the Ordinance Act, saying that interim compensation should be payable, that should not be taken away. That by taking it away, the ordinance is unconstitutional. The writ petition was filed. The High Court of Andhra Pradesh upheld, High Court of Andhra Pradesh held that the ordinance is ultra vires. After that, a second writ petition was filed and also directed, sorry, my lord, first held that the ordinance is ultra vires and also directed the government to make payment of the compensation immediately. Government did not make payment of the compensation. So second writ petition was filed by the Raja of Venkatagiri asking for mandatory mandamus directing payment to be made. Again, an order was passed there. In the meantime, while these two orders were passed in the writ petitions filed by the Raja of Venkatagiri, another set of writ petitions were filed by similarly placed persons whose land had been taken away and no compensation was paid. Similar order was passed so far as declaring the declaring the not granting of compensation to be bad, and also directing that compensation should be paid. In the meantime, from the Raja of Venkatagiri's matter, the matter went to Supreme Court. In Supreme Court, there was a consent order by which the vires of the act was upheld and it was held that final compensation will only be payable. In the meantime, the matter came, the other sets of writ petitioners, they again went to court in the High Court and said that we have an order in our favor by which direction has been made to make payment to us. Notwithstanding what has happened in Supreme Court, since the order which we have got has not been challenged by the Andhra Pradesh government, so the money should be paid to us and pass a mandatory order. The High Court of Andhra Pradesh passes an order of mandatory mandamus directing payment to be made. From that matter went to Supreme Court. This is that order. 3 issues were there before Supreme Court, which your lordship will find in paragraph 6. Paragraph 6. ABC.
Yes.
The lordship will see, can the decision of this court dated 6th February 1986 upholding the constitutional validity of the Amendment Act 1971 reversing the judgment of Andhra Pradesh, state of AP versus Venkatagiri. This is the Raja of Venkatagiri's matter. And further indicating that period during which interim payments are payable under the Act ends with the date of original determination made by the director under Section 39 of the Act, held to be law declared by the Supreme Court under Article 141 of the Constitution, or can it be said to be per incurium as contended by Mr. Rao? Second question, the judgment of Andhra Pradesh in favor of the respondents passed in WP number so-and-so, these are the second set of writ petitions, not being challenged by way of appeal to the Supreme Court, even though it merely followed the earlier decision of the High Court in Venkatagiri case, whether has conferred indefeasible rights on the respondent, notwithstanding the reversal of the judgment of the High Court in Venkatagiri case by the Supreme Court. So rather convoluted way of framing the questions. But since the parent order has gone, now that relying on the parent order, another order has been passed, whether that order is good or bad. And third question, whether the High Court would be justified in issuing mandamus in the changed circumstances, namely Supreme Court reversing the judgment of the High Court in Venkatagiri case, inasmuch as for issuance of mandamus, one of the condition precedents which is required to be established is the right subsisting on the date of the petition. So these were the three issues. Supreme Court, first and second, holds that the first order of Supreme Court is the law of the land. Since that is the law of the land, therefore, anything that has been done subsequently, one who does not have a right cannot maintain a petition. It is in this light, my lord. Now, if your lordship reads paragraph 17. Well, if your lordship takes para 16 first, my lord, at page 658, it's a very long paragraph, but paragraph 16 at page 658.
Some more time. I'll release the other matters.
Yes, my lord, I'll need some more time because I just have to lastly show my lord a few things from our facts and I'll conclude, my lord. My senior comes, he's on his way also, I'm told. But I should finish, my lord, fast. If your lordship is.
Shantanu, other matters released for the day.
Other matters are released for the day. Item except number 6.
We conclude, my lord. We are absolutely right. Well, if your lordship takes para 16
Yes.
at page 658, it's a long paragraph. I'll just show the relevant portion, my lord. My lord, middle of the paragraph, starting with it would in fact lead to an anomalous situation. But page 658, just above para 17, middle of that page, my lord. Well, page 658, above para 17, middle of the paragraph, it would in fact lead to an anomalous situation. My lord, have your lordship found it, my lord?
Oh. Will tell me the
My lord, if your lordship sees placetum C,
Placetum C, yes.
placetum C, right after placetum C, next sentence, it would. Well, page 6.
Lead to an,
Yes, ma'am. It would in fact lead to an anomalous situation if, in the case of respondents, the earlier conclusion that the Amendment Act is constitutionally invalid is allowed to operate notwithstanding the reversal of the conclusion in Venkatagiri case, and only in Venkatagiri case, or where the parties have never approached the court to hold that the same is constitutionally valid. This being the position, notwithstanding enunciation of the principle of res judicata and its applicability to litigation between parties at different stage, it is difficult for us to sustain the argument of Mr. Rao that an indefeasible right has accrued to the respondents on the basis that the judgment in their favor, which had not been challenged, and the right could be enforced by issuance of fresh mandamus. On the other hand, to have uniformity in law and to have universal application of the law laid down by this court in Venkatagiri case, it would be reasonable to hold that the so-called direction in favor of the respondents becomes futile inasmuch as a direction was on the basis of an Amendment Act which is constitutionally invalid, the moment the Supreme Court holds the Act to be constitutionally valid. And then, my lord, paragraph 17, if your lordship turns over and recital B, placetum B, 2 sentences after placetum B, in other words, existence of legal right of a citizen and performance of any corresponding legal duty by the state or public authority could be enforced by issuance of a mandamus. Mandamus means command. It differs from writ of prohibition or certiorari in its demand for some activity on part of the body or persons to whom it is addressed. Mandamus is a command issued to direct a person, corporation, inferior courts, or government, requiring him or them to do something therein specified which appertains to his or their office and is in the nature of public policy. A mandamus is available against any public authority, including administrative and local bodies, and it would lie to any person who is under duty imposed by a statute or by common law to do a particular act. In order to obtain a writ or order in the nature of mandamus, the applicant has to satisfy that he has a legal right to performance of the legal duty by a party against whom the mandamus is sought or of such right. It is on this basis, my lord, that Supreme Court makes this observation. That is all. So, my lord, there was no question of, my lord, an entry which we have made by way of a legal agreement. We have made the entire payment. And so facts are altogether different. Here, the question was on the basis of Supreme Court judgment, the right has been taken away altogether. My lord, if your lordship gives leave for my senior to this address, judgment gulo distinguish kore diyechi.
I would like to finish it as soon as possible. The note, we have come, as I had submitted, we have come with a short note of my submission. First, a list of dates.
It over a copy to learn it now.
Yes, I am making. আমাকে এনগ্রস দিয়েছো কেন? ঠিক আছে। But just briefly, the list of dates. The allotment was made on 23rd October 2007, the first page. And 6th November, made the full payment. Possession given to us, third date, 4th February 2008. Now, license executed on 12th March 2008. Then between March 2008 and August 2009, we first got the mutation done. That took, because the property was not assessed in the KMC records. It got done on 8th of August 2008. And from 8th August 2008, the property was assessed in the KMC records. Then the survey and architect was engaged. We got electricity connection, and we built the boundary wall. This whole thing took 1 year, preliminary year. That included the assessment of the land. 5A is very important. 12th February 2009, the meeting of the pricing committee of KMDA presided over by the mayor and several senior bureaucrats held on 12th February 2009. A decision was taken to levy penalty in cases where construction work could not be started within the specified time. The penalty rates were also prescribed. 12th February, at the 159th authority meeting of the KMDA, the policy for levy of penalty in case of extension of construction work was also extended to cases where construction is yet to start. The second one should be
They are not replying, they are re-arguing the case.
not re-arguing.
This has already been placed.
I'm
So
placing
reply on law.
Then, my lord, on 1st October 2009, we give notice to KMDA regarding commencement of construction work. And hearing is held on 10th November, where we asked to bring all records. 24th November 2009, we give the project implementation schedule. Also, can you come to serial number 9? 15th September 2010, petition number 1 obtained NOC from fire. And we informed this in course of hearing. And then 15th December 2010, the MBC approves the plan, serial number 11. Municipal Building Committee approved the building plans. Thereafter, it was beyond my hands till the plan was sanctioned thereafter in June, 6 months. But in between, my license is cancelled on 21st February 2011. And Lordship will kindly come to serial number 18, though I get the stay. Lordship, before that, serial number 17. I get an order of High Court in the said petition staying the operation of the cancellation letter and restraining KMDA from creating and or encumbering any third-party rights over the said land, and directing us, petition number 1, to not raise any further construction. In the meantime, on 13th June 2011, KMC, another organ, sanctions the plan. And I pay the full sanction fee of 44 lakhs. And then comes the 20th, and then so there's a hiatus. So for 9 years, writ petition is pending. Writ petition is finally disposed of on 25th September 2020, rejecting the matter to be reconsidered. And then I'm not troubling Lordship with the facts. It's been reheard, and the same order was made. Now, Lordship, kindly come to my note. This is my rejoinder on interpretation of clause 4.3. I'm sorry, but I have to cite one judgment in new and rejoined. Interpretation of clause 4.3. Whether there was at all any delay by the petitioner in starting construction in light of clause 4.3 requiring construction to be in accordance with plan as sanctioned by the appropriate authority. This has to be seen. KMC mutated the land on 28th of August 2008. Only after this could the petitioner apply for fire NOC, which was granted 15 September. Thereafter, MBC approved the plan on 15 December 2010. But thereafter, the plan was sanctioned after 6 months. The petitioner immediately paid the sanction fee. Now, Lordship, kindly come to paragraph A2 of my note. Since the contractual clause is that paragraph, yes, A paragraph 2. Yes, paragraph 2. Same page. Same page, paragraph 2, on interpretation of clause 4, because that's the first thing. Since the contract clause is that construction has to commence in accordance with the plan as shall be approved by the appropriate authority on payment of such fees as required in accordance with the building rules of KMC and comply with the requirement of land use and control regulations. The time taken for obtaining approval sanction will have to be taken into consideration by KMDA while determining whether or not there has been delay in commencement of construction. Well, this is my first submission. Paragraph 3, apart from this being the reasonable interpretation of the deed of license, it is a cardinal rule that interpretation of contracts should be in such a manner as would be equitable to both sides. Lilly's Supreme Court Canada's case. This is especially so in cases where the contract document is prepared by the authority, here KMD, in its own standard form. The doctrine of contra profferentum also applies. Lordship, please see in this these are the new judgments. Lordship kindly permits me to cite. Of course, they will, they want, they can distinguish. Lordship, director. This is the Lilly's case. Paragraph 52, page, this is page 15. Contractual interpretation and the intention of the parties. In order to ascertain whether the supply agreement conferred or had the effect of conferring a sublicense upon Apotex, it is necessary to consider the proper approach to the interpretation of such a contract, and in particular, the evidence which may be considered in this respect. In Consolidated Bathurst, so and so, Justice S.T., writing for himself and Pigeon so and so, offered the following analysis. Even apart from the doctrine of contra profferentum, as it may be applied in the construction of contracts, the normal rules of construction lead a court to search for an interpretation which from the whole of the contract would appear to promote or advance the true intent of the parties at the time of entering into the contract. Consequently, literal meaning should not be applied where to do so would bring about an unrealistic result or a result which would not be contemplated in the commercial atmosphere in which the insurance was contracted. Where words may bear two considerations, the more reasonable one, which produces a fair result, must certainly be taken as the interpretation which would promote the intention of the party. Similarly, an interpretation which defeats the intention of the parties and their objective in entering into commercial transaction in the first place should be discarded in favor of the interpretation which promotes a sensible commercial result. And next paragraph, first few lines. From this passage emerge a number of important principles of contractual interpretation. Not all of these, however, apply to the instant appeal. One which surely does not is the doctrine of contra profferentum. Contra profferentum operates to protect one party to a contract from deviously ambiguous or confusing drafting on the part of other party by interpreting any ambiguity against the drafting party. When both parties are in agreement as to the proper interpretation of the contract, however, it is not open to a third party to assert that contra profferentum should be applied.
My lord, this is so here, my lord. When after all I've got the land in in the license is in October 2007. I get possession in February 2008, and more importantly, the land was not assessed in anybody's record. That took almost that took 1 year, October to August, 10 months to get the land assessed, and then not get a plan sanction after all the NOCs. It was done at the earliest possible opportunity. And when the contract says commence construction in accordance with all the approvals, then one has to look at it in that perspective. Lordship, one more judgment, Lordship, or two more judgments actually. The Patna High Court judgment of Sisina, EIR 1945, Patna, page 447. আশুতোষ মুখার্জি আছে না এটা আশুতোষ মুখার্জি হ্যাঁ ওটা আশুতোষ মুখার্জি paragraph 4 of this
has a copy of these judgments.
I'm giving them all.
Paragraph 4?
4 is not there. You can give me one. Huh?
Page 4. Numbering is
at page 4, Lordship kindly comes to the
There's no page 4, it's 441.
the second last page.
Yes.
কোথায়
second page at internal page 4 is 442 এইখানটায়
কোথায়
the terms
Internal page 4?
internal page 4 এইখানটায় there is no
yes my internal page 4, the page 442.
Yes.
The last, the terms of the covenants, Lordship. The terms of the covenants should be interpreted on two well-established principles. The contract under which exemption is claimed must be strictly construed against the claimant, and it must appear from its terms beyond the possibility of any dispute that the parties intended to vary the liability as imposed by the statute, and that the construction to be placed on a deed ought to be such as to render, such as to render it reasonable rather than unreasonable, and will make it just to both parties rather than unjust to one of them. In the present case, there is no express term in the contract to justify the appellant's contention that the parties intended to vary the liability as imposed so and so. I'm only on that. So it should be to achieve a just outcome, not an almost impossible. After all, I'm paying. Because after all, they've also been given the power to extend the time. And one last judgment, that is, copy down.
Yes.
आगे पेज last in the second place in the
Yes.
place.
Ashib, the second page, the third page, under page 157, third page 157.
Yes.
The last 7 lines of that page.
Yes.
In the second place, it is well established that the construction to be placed on a deed ought to be such as will render it reasonable rather than unreasonable, and will make it just to both parties rather than unjust to one of them. In other words, as Justice Phillips in McElroy versus Slope, a court should always prefer that construction consistent with the language of the deed, which will prevent one of the parties from obtaining an unconscionable advantage over the other. Now, I am on this. After I've spent 44 lakhs over and above what I've spent here for sanction fee, 2 crore 35 I have given them for the land. Now to lose it,
That's all your submission?
that's all on this. My next point is arbitrariness. Well, next is B, arbitrariness and discrimination. This also had, even in contractual matters, doctrine of arbitrariness and discrimination ought to be looked into when the state authority is a party to the contract. This I had placed in Terry Oat Estates. There was a letter of allotment issued by statutory authority in terms of which the lessee was to make payment of premium by installments. The allottee failed to make payment of the installments of premium, and accordingly the authority took steps to resume the land and forfeit the money deposits. The Supreme Court considered whether the drastic power of resumption ought to be taken, even if such power is vested in the authority. Doctrine of proportionality was applied to the contractual matters, and the Supreme Court, after taking into consideration the allottee's willingness to pay off the outstanding amount with interest, quashed the forfeiture. The Honorable Supreme Court noted that the allottee in that case did not have any dishonest or ill motive in not making payment in time. In this case also, the respondent authorities have not found any dishonest or ill motive on the part of the petitioner delaying the commencement of construction. Paragraph 6. In a similar case of land allotment and subsequent forfeiture, the Supreme Court applied the doctrine of proportionality and quashed the drastic action in Hariom Enterprises. Now this was followed by Justice Banerjee, Indira Banerjee, as in Austin Distributors. Now, paragraph 7, yes. Even in other contractual matters, that is not land allotment cases, doctrine of reasonableness is applied while assessing the exercise of contractual rights by a state authority. Electricity matter. Oh, this is new. This I may hand up, but I need not place anything. 23/8/6, very recent judgment after my opening submission was. And also my last point, which is the last page. KMDA is bound to follow the law laid down in Austin Distributors versus State of West Bengal. This is their case interpreting identical. In other instances of delay in commencement of construction, KMDA has not forfeited the allotment, but only claimed penalty. Ultimately, that was also struck down. And that is also the public policy, as also the policy decision as more fully quoted in paragraph 19 in WP so-and-so. KMDA cannot act contrary to the law laid down by this Honorable Court in a similar case of land allotment, where the license deed, which has a clause for commencement of construction within a time period followed and consequent forfeiture in case of delayed commencement. High Court held that the drastic power of resumption and forfeiture should be undertaken as a last resort in the absence of the statutory enactment or any express term in the lease deed, and that too with retrospective effect, even levy of penalties back. The law laid down in this judgment is binding on KMDA, and KMDA could not have acted contrary there. Well, actually, in fact, this C should be after paragraph 8. Paragraph 8 is a part of the arbitrariness point. That's why I was. And Lordship, the last, have you shown? Now, KMDA's policy to levy penal charges has since received judicial recognition in Damodar Prasad Agarwal. In fact, this was the judgment cited by them. May I show this? The division bench in that case noted the levy of penal charges as per the said policy, and that termination is only after failure to pay the penalty. This was my law's judgment in as affirmed by the division bench. Lordship, these were handed
to this earlier.
No, but they had relied upon it. So this I want to.
These are judgments downloaded from the website of the High Court of Calcutta.
The names of the parties
Damodar
Prasad Agarwal versus State West Bengal
should be there.
These are judgments relied upon by the KMDA.
Yes.
Damodar Prasad, yes. Division bench judge.
Yes, a division bench will. Single bench was my lords as by the division bench without interfering, but there's a judgment of the division bench.
If it is not available, I'm.
Is there?
Or should the single bench, or should kindly comes to the fourth from last, at the bottom, fourth from last.
Internal page 6.
Internal page numbers are not.
On top of the page.
Oh yes, I am grateful. My internal page 6. Internal page 6, last paragraph. Be that as it may, even without such demand of penal charges being taken into consideration, it appears the deed was cancelled due to breach of the terms of thereof by the petitioner. A technical lapse in clause 4.1 of the deed has been pointed out by the petitioner. Such provision enables the petitioner to re-enter into the land upon breach of any of the terms of the deed of lease, but does not specifically indicate that the lease may be determined by the authority. It's needless to say that re-entering of the authority into the property presupposes determination of the lease, and as such it cannot be inferred that the provision entitles the authority to determine the lease in clause 4i of the deed and thereafter to re-enter the premises. Here, I would more rely upon the division bench where this penalty was. Oh, Lordship, my mistake. Page 6, second paragraph. Second paragraph. It is a fact that the provision of payment of penal charges. This is what I was meant to say. It is a fact that the provision of payment of penal charges as recorded in the policy decision of the authority is not included in the deed itself. And admittedly, such policy decision was not intimated to the petitioner or the other allottees prior to execution of the deed or even subsequently. Therefore, such policy decision cannot be given much weight, and the deed could not have been cancelled for non-payment of penal charges as demanded by the authority in terms of the policy decision. But Lordship, what I'm saying is that, of course, the respondent submit that the lease was cancelled in terms of 4i. But Lordship, what I'm submitting is there's a policy decision to levy penal charges. So why not apply it to my case? Why straight away go and cancel? And this was considered by the division bench. Lordship, I just missed out. I don't know why I missed out. The first paragraph of this page.
Yes.
Following the said reply, first line, 28th of February, KMDA issued a demand notice for penal charges on 9th August. Upon the petitioner failing to comply with the notice, allotment was cancelled. But here in my case, straight away cancelled. This is what I was showing. If there are and I have given two instances which I could find out, which has not been denied in the reply. And in the division bench, page. The division bench has also noticed the same thing, page 20 of 24. And this was a much more reasonable term. Page 20 of 24, this is Arijit Banerjee's judgment, paragraph 2. The deed of license is a later deed of license executed by KMDA in favor of the appellant essentially constituted a contract between the appellant and KMDA. Contractual relationship between the two parties were to be governed by the terms of the contract. One of the conditions of the license deed was that the licensee allottee of the plot in question would construct a building on land within 5 years. Much more here, if it had been 5 years, we would have done it. Admittedly, the appellant failed to make any construction within the stipulated time. The next Lordship, paragraph 4, next page.
Yes.
The last 4 lines of paragraph 4. Oh, Lordship, may I please paragraph 4? The relationship between the appellant and KMDA was purely contractual. The appellant was admittedly in breach of a contractual term. The contract license deed authorized KMDA to cancel the license upon breach of the speech by the appellant. Next sentence is very important. KMD exercised such right and cancelled the deed. Prior thereto, in terms of a policy formulated by KMD, it agreed to accede to the appellant's request for extension of time for making construction upon payment of penal charges. Appellant pleaded inability to pay such charges. Thereupon, KMDA cancelled his license. This is exactly my case, my lord. This is the policy. This is from 2009, before my before my license was cancelled. My opening submission and this really supports. This is 96th license deed. Well, and while about contractual matters, Lordship kindly see Justice Indira Banerjee's judgment in this case only. The same argument was advanced, relying upon Haldiram Bhujiawala's case by Justice Joyanta Biswas, and the court said, and also and by relying upon all the Supreme Court judgment Hari Om Enterprises, even in contractual matters, the state's arbitrariness is to be considered. But this is my utmost.
But in fact, my lord,
You need to make further submissions on
Yes,
these
because my learned friend is trying to stretch the scope of the writ from the bar, submission from the bar.
Will you come back?
Interpretation, discrimination, arbitrariness, all these points are newly argued.
No, I had argued all this. The only thing I've newly argued is on the interpretation for which I have new judgment. All the others were my earlier judgments. I've given nothing new.
After
So we
vacation,
should be
Mr.
given
After vacation,
Next week, Lordship said just now.
just have a week to go.
I leave it to my. It's entirely up to my.
Any day, few minutes, give us.
Lordship will kindly mark it, Pathar. Otherwise, it will be injustice.
Immediately upon reopening.
But just in case the bench, even this will be very. I also don't hope and think so, but it will be very, very unfair to both sides in case it is. In case.
It will be difficult.
Lordship, without saying Pathar, Lordship kindly says something so that afterwards, if need be, we can go and bring it to my lord. I know Lordship doesn't want to say Pathar, but Lordship kindly record that I have finished my.
It's very difficult to carry matters of one determination to the other.
I know that. That's why I'm saying it's only 15 minutes for the three
it
judges.
will not take much time. Come back on 9th January, immediately upon reopening. Heard learned counsels for the parties at length. Paragraph, with the matter appear under the same heading for further consideration on 9th January 2024.
Lordship, the interim order is till 15. Lordship, kindly extend this.
Comes on 9th January.
9th we are
or
coming.
15th,
9th.
if necessary,
So
extend after that.
At 3:30.
Very
Yes.
marked at
Marked
3:30.
as 3:30. Then we
It
get
is
just
on the verge of completion, yes.
we have no my lord, difficulty if it is in the this side of vacation.
I don't want to keep it pending for the vacation. Please come back.